I'd like to have us get started today. Start with our land acknowledgement, and then I'm going to welcome Dean Kelly to give us a welcome. The University of St. Thomas occupies the ancestral and current homelands of the Dakota people. By actively committing ourselves to truth-telling, relationship building, wound healing, and justice seeking, we humbly offer our respect to the Dakota elders and people, to indigenous communities beyond the Dakota, and to the sacredness of the land where the waters reflect the skies. Minnesota, Coche. Dean Kelly, if you could offer a quick welcome.
Thanks, Professor Organ and Professor Hamilton, Professor Granardo. Thanks to everybody for coming here to the University of St. Thomas School of Law. My name is Dan Kelly. I have the privilege of serving as Dean and Mengler in Law here at the law school. Fantastic evening last night for those who were able to attend. We were able to honor the Holloran Center on its 20th anniversary. Amazing accomplishments, amazing track record of forming ethical leaders, and really spreading the word nationwide in terms of the importance of professional formation. We were also able to honor Neil and Uvi Hamilton, who have made such contributions to law school. Neil was founding faculty member when the law school opened its doors in 2001. 5 years later, in 2006, obviously the founding director of the Holloran Center. So let's give it up for Professor. Several speakers, including Neil himself, last night who talked about providential moments. And one of the reasons why I think today's workshop is so important and the continuing work of the Holloran Center and all of the work that you do at all of your respective law schools and universities is because of new challenges, such as artificial intelligence. And this really came home to me, and I think maybe most importantly, to Professor Hamilton, because we've really been thinking about the challenges and opportunities of AI. And Professor Hamilton, I think, had a light bulb moment, or maybe it was a discussion with Uvi several months ago, in which Uvi and Neil in this conversation pointed out, well, given AI and what AI is able to do with knowledge and information, the things that the Holloran Center is doing on professional identity formation and on judgment, character building, emotional intelligence, those things are going to become even more important. Even more important. So combining, and this is what we're trying to do at the law school right now, combining competency and expertise in AI for all of our aspiring lawyers with those professional formation skills and practical training, that makes all the difference. So Professor Hamilton, even though he is approaching retirement, is all in on ideas and thinking through new challenges. And so I encourage all of you to take that same mentality. In fact, when I got home last night from a wonderful celebration, I had an email from Professor Hamilton talking about Monday's faculty meeting, encouraging leadership to step up. So he is still all in, and I encourage all of you to be too. So welcome, and thanks so much for being here.
So I will also try to be brief because I want to make sure we get started on time and maybe ahead of time. But I was reflecting and preparing for this 9 years ago. So 9 years ago in February, on a day that was actually a lot like yesterday, we had a day. So on Friday, we had a Law Journal Symposium, and it was a transition point, kind of like where we are right now. We were celebrating the 25th anniversary of the McCrate Report, the ABA McCrate Report, which talked about the importance of values and skills that lawyers needed and law schools should emphasize. And we were also noting the 10th anniversary of Educating Lawyers, which talked about the 3 apprenticeships associated with professional education generally, not just lawyers, but gave us the concept of professional identity formation, right? And so we had a symposium, kind of like today. Frankly, some of the people here today were at that symposium sharing their insights and wisdom. And then the next day, which was a beautiful Saturday in February, it might have been even a little warmer than yesterday, we had a workshop. And so we convened 35 to 40 people to talk about learning outcomes associated with professional identity formation and begin the process of developing Holloran competency milestones. And so over the next 3 years, we probably had the original group. There were 5 working groups, maybe 25 people, 24, 25 people. And then we added another set of working groups the following year, another group of about 20 people. And over 3 years, we generated nearly a dozen stage development rubrics, Holloran competency milestones. And I think we now have 14 on our webpage. So I was thinking back to just that fact that many of the people who will be speaking with you today were there 9 years ago, speaking to you at that point in time. And that was a point in time before we had an ABA standard, right? So that was a point in time where, to some extent, I think that gathering amplified the momentum of the professional identity formation movement and created the traction that led to ABA Standard 303B3 that now requires all law schools to provide opportunities for professional identity formation. So I'm thrilled that we have the people we have with us today. This is a little bittersweet, right? Half of our panelists today are here because they're really good friends of ours and they're really thoughtful people, but they have made decisions either last year or this year to retire from the legal academy. And so we really wanted to make sure they had a chance to share their wisdom with us. And then we sent out, so that was kind of the core group we invited for this. And then we sent out a request for proposals to kind of fill out the panels for today. And we have some wonderful, what I might call next generation scholars ready to continue to carry this project forward. So on behalf of Neil and David and Felicia and our Holloran team, I am thrilled to be gathering here today. So this is we're calling it our first annual conference and awards dinner. The first annual conference is the first annual conference and Law Journal Symposium. For that, Neil and I have to thank David Granardo. It was his idea to try and do this. There will be a second annual conference and awards dinner. We don't know if it will also be a Law Journal Symposium or if it'll be a workshop or what it will be exactly. But we will have something like this, a second annual conference and awards dinner next year. And we're really excited to be starting that new tradition this year. So with that, let me welcome you all. I'm thrilled that you're all here. And let me invite Corey Kibble, who will be moderating our first panel.
Hello, welcome, and good morning. Our first panel today is on where we've been and where we're going. First, we're going to welcome up Daisy Floyd, Dean Emerita, I'm not sure how to say that version of the word, of Mercer University School of Law. Next, we'll have Benjamin Madison, who is the director of Regent Law School's Center for Professional Formation. And finally, we will have Lou Bilionis and Neil Hamilton speaking as a pair. Lou is the Dean Emeritus of the Droege Professor of Law at the University of Cincinnati College of Law. And Professor Hamilton, I'm sure many of you are aware, is a professor here. He's the founding director of the Holloran Center for the Ethical Leadership in the Professions. After our speakers, we will have some time for Q&A. So I'll welcome up Daisy Floyd.
Thank you all. Good morning. It's a pleasure, as always, to be at Holloran. I want to thank Neil, Jerry, and David for including me. It's wonderful to know that even when you decide to give up things like faculty meetings and committees, that you can still be invited to share your ideas and to be around people whom you love and care about and want to work with. It's always a pleasure to be here. I took the theme of the conference and decided to make that the theme for my presentation. And I hope that you will indulge me a little bit. What I decided to do was to take a personal look at my own journey in professional identity formation. And I think there are lessons there that can be shared broadly. Maybe it will give some of you a little bit of a glimpse into the history and also see the ways in which those of us who have been trying to get a handle on what professional identity formation means, some of the turns that we've taken and the missteps maybe along the way and where we are today. So I'm going to begin with the beginning for me in professional identity formation. And it began in a hotel ballroom at the Marriott Wardman Park in Washington, D.C., almost 30 years ago. I'm pretty sure it was 1999, I think. Those of you who have been to annual meetings of the Association of American Law Schools, which includes the professors in the group, will recognize that's not actually the ballroom. It was a larger ballroom. The litigation section had presented their program. I was trying to be a good citizen and decided to stay for the business meeting. And at the beginning of the business meeting for the litigation section, this person rose to spoke and she changed my life. This is, some of you recognize her, Dean Judith Wegner. Judith at that point was the recent past president of the Association of American Law Schools. She was dean at the University of North Carolina School of Law, and what she announced to the group was that she was, after her deanship, going to go to work for the Carnegie Foundation for the Advancement of Teaching, and that the Carnegie Foundation, as part of a study of professional education, was beginning a study of legal education. And Judith was leading that effort. And so Judith announced that as part of that, there would be a team of people visiting law schools, interviewing faculty, staff, and students about their experiences, taking a sociological approach to understanding legal education. And there would be a group of, I think it was a dozen, maybe 15 or 16 faculty around the country who would be teaching courses called Carnegie Seminars on Legal Education to help inform the work. Well, I heard that. I thought, well, that sounds interesting. And Judith said at the end of her remarks, if you have any questions or are interested in learning more, let me know. So for the students in the group, this was our form of communication in 1998 of professional meetings. There was a huge, it was not this neat, by the way, but there was a huge bulletin board in the hotel lobby. And if you wanted to leave a message for somebody, you left a message. You know, they were divided alphabetically. I wrote a note to Judith, and this was kind of out of character for me, but I just wrote a note and said, I just heard you talk about what you're doing. I'd be interested in being a part of these seminars. And left a note. I thought, well, I'll probably never hear from her. Went back to my hotel room to leave my bag. And this is what telephones used to look like. As I was walking into my hotel room, the phone rang. And I picked up the phone, and the voice on the other end said, "Is this Daisy?" I said, "Yes." She says, "Hello, this is Judith Wegner. I got your note. What is it you would like to explore as a topic in legal education?" Now, I had about 3 seconds, and to this day, I don't know why, but these were the words that came out of my mouth. I don't know where I'd ever heard that phrase, professional identity. I might have gotten it from some of Bill Sullivan's work. I don't know. I don't know where I was exposed to that. But I found coming out of my mouth saying, I'm really kind of interested. I think I'd like to explore the ways in which students develop their professional identities in law school. Now, the reason this was of interest to me is I was then in my maybe 6th or 7th year serving as Associate Dean for Academic Affairs at my then school, Texas Tech University School of Law. And in that role, you deal with a lot of issues that arise, including students who are struggling with legal education and their experiences in law school. I too had struggled with my experience in law school, and so I think I had a special affinity for some of those students. And in that role, I also was working pretty closely with the Texas Lawyers Assistance Program, which was one of the leading lawyers assistance programs in the country. They were very interested to help us in law schools, and I was beginning to get a sense that there was something happening in law school to our students that we needed to understand better, and that what was happening in law schools was having some effects for lawyers down the road. So this began for me a really generative decade in my professional life because I was able to develop a relationship with the Carnegie Foundation for the Advancement of Teaching, which again, changed my life. So what I want to do is share some of those projects and what those taught me about legal education. So Judith did invite me in to teach a Carnegie seminar on legal education. I was too naive at the time, by the way, to realize I think she had handpicked all of the other people and wasn't really looking for volunteers that day. But nonetheless, I was graciously invited into the group. So I had a chance to create a course where I could just ask questions of students about things that I wanted to know. So I created a course, and I know this is small print, you may not be able to read it, but I went back and actually found my course description from then. These were the topics that I wanted to talk about with students. What's going on in legal education? How does that fit in with the history of the profession? What are the roles of lawyers? What's happening as you go through law school? The pedagogy that I used, I assigned readings. We did small group discussions. It was 12 students. It was a seminar setting. We did some reflective essays. Every student wrote some kind of research paper. We actually did weekend retreats for several semesters, which were really wonderful. We brought in, had a friend who was a theologian, had a friend who was a psychologist, had a friend who was a federal judge. I just called in all the favors I could, met with the students. We just talked about their experience of law school. And it was really revelatory to me. And out of that experience, I got to do something else with the Carnegie Academy. And I'm going to digress for a moment to explain what this is because it's relevant, I think, to where we are today in professional identity formation. So the Carnegie Foundation at that moment, in addition to doing the preparation for the profession studies, was also involved in what they call the Carnegie Academy for the Scholarship of Teaching and Learning. And the goal then of the Carnegie Foundation through this program was to help develop teaching in higher ed classrooms. And because I had been doing this work on the Carnegie Seminar on Legal Education, I was able to make a proposal to this other Carnegie program and say, well, I'd kind of like to further this work through the Carnegie Academy for the Scholarship of Teaching and Learning. This is a picture of my cohort in 2001. You can see, I think there were 30 of us. There were 2 law professors. We were the only law professors in the group. So part of this model was to have interdisciplinary conversations around teaching and to learn from each other. We were divided into smaller groups for our discussion. We had leaders from the year before. We got to spend 2 week-long residencies in the summer in Palo Alto and then 2 shorter residencies in January of each year. So you had a group that was holding you accountable for your work. And here's what the Scholarship of Teaching and Learning said. It said you begin with some teaching problem. You apply scholarly principles to try to resolve that problem. Inquiry, research, discovery, accountability. We're going to bring teaching out of the black box of the classroom. We're going to share it with our peers. And our mantra was, we are making the invisible visible, which, by the way, I think has resonance for professional identity work. And the goal was to improve our own and others' teaching and to create a field of scholarly inquiry into teaching. All right, so what was my problem? My problem was, how do we in law school affect the formation of professional identity of American law students? And because I was coming at this from a perspective of seeing a lot of distress and maybe negative consequences of legal education, this is how I formulated the questions that I wanted to ask. What seeds are we sowing in law school that are manifested both positively and negatively in the profession? And to the extent that what we're doing is sowing the seeds for unhealthy, unhappy, and therefore incompetent lawyers, what can we do to mitigate that effect? By the way, one of the readings was Judge Schultz's article you may be familiar with, How to Be Happy, Healthy, and Ethical in an Unhappy, Unhealthy, and Unethical Profession. So this was my problem. Now, what I discovered as I was continuing to do this work is there were lots of other people asking similar questions, maybe not using exactly the same language, but it was a very kind of fertile time in legal education and the profession for people really trying to get a handle on maybe doing things a little bit differently. Stephen Keever wrote a book called Transforming Practices. Steve and I became friends. He helped teach the course. We didn't have Zoom back then, but he called in for a couple of sessions. Professor Larry Krieger at Florida State created something called the Humanizing Legal Education Movement. Right there in the title, you can see he said, we need to have more humanity in what we're doing in legal education. It started off as a listserv, by the way, which we thought was fancy and helpful technology, which it was at the time. There was a religious lawyering movement. How do we let people bring their faith into their professional lives? Therapeutic jurisprudence. Can we as lawyers be therapeutic in the lives of our clients? The Lawyers Assistance Program I've mentioned before. Clinical legal educators were asking all these questions. There was collaborative lawyering. How do we have divorces that don't make things worse but make things better? There was holistic lawyering. I'm sure I've left some things out. But this very ripe moment for people asking these questions. Well, here's what I discovered in my work from my students. So students said, sometimes this is how we feel being in law school. It's wonderful, it's great, it's fantastic. But sometimes it feels more like this. And when we started unpacking it, here's what the students told me. They love meeting interesting people, forming new relationships, gaining legal knowledge, the thinking like a lawyer that we're so good at, we're good at it. And that brings a lot of rewards. They told me they had an increased sense of confidence, independence, accomplishment. They can articulate arguments, see things from other people's perspectives. They can depersonalize disagreement. All that was great. Here's what wasn't so great. There's a focus on external rewards. If I quiz you, you could probably tell me what the prizes of law school are. They learn about those during orientation, right? Very quickly. That can lead to feelings of inadequacy or failure, a loss of sense of self and sense of purpose. To me, that was the most devastating thing that I learned from my students, this loss of purpose, a devaluing of emotions and of personal values and of harm to relationships. And then what helped? Well, actually the course, just having a course was helpful, they said. Why? Because we were naming it, we were discussing it, there was reflection, and they were connecting with lawyers and they were connecting with each other. So this was helping me understand what maybe we could be doing differently in legal education. It also led to my first publication. It was a page-and-a-half long, was in a teaching newsletter, but it was the first time I ever wrote anything about professional identity formation. So it also opened up to me that maybe this was an area that we could write about and share. All right, so then in 2007, Carnegie Report came out, as we call it, Educating Lawyers. Bill Sullivan, the lead author, is here. Carnegie Report really lit a fire under this work that was already bubbling up organically nationwide. And the Carnegie Report asked questions about professional identity. Professional identity is asking our students, who am I as a member of the profession? What am I like? What do I want my role to be? And how do I place the ethical social values into that sense of identity, and helped us understand how to do it. We needed to help our students encounter role models and exemplars, to connect with lawyers and other models of ethical commitment, and of course, to reflect on what's happening to them as they develop their professional identity. Well, the Carnegie Report gave people power and permission and support to explore these issues further. So 2007 was a real turning point, as you all know, and you've heard and you've seen, witnessed to in legal education. I want to just, on my own personal journey, make one more comment about something that I learned a great deal from with the Carnegie Foundation, and that was when I was invited in to be a part of what was called a cross-profession seminar that resulted in a book, and the book is called A New Agenda for Higher Education, Shaping a Life of the Mind for Practice. The theory behind this book was that undergraduate liberal education and professional education ought to learn from each other. That undergraduate education was about shaping the life of the mind. We were about getting people ready for practice. And maybe if you brought those together, we could change higher education. What was personally meaningful for me and how it kind of affects this journey is that I was invited in because Bill saw something in the work I was doing that had to do with practical reason or practical wisdom. I didn't see it that way. And when I was invited in, I was like, okay, fine, but am I doing this work? I don't understand. I don't know about it. I often say that my favorite definition of a mentor is someone who sees something in you that you don't see in yourself. And that was a moment for me. So that project started me really trying to understand practical wisdom, practical reason, and how those fit into the development of professional identity. All right, what were the takeaways? Well, younger people in the room, go to meetings. Go to meetings. If I'd not gone to that meeting, or if I'd left before the boring part, I would not have had this journey that I've been on. Lean into your naivety. If I had realized that Judith was announcing a project already established, I would not have left her that note. And so that's one of the takeaways for me that maybe affects professional identity. Interdisciplinary work has been so valuable to me. Ask students about their lives, listen to their answers. We think we know what's going on, we don't. We need to ask them. Having a group like Carnegie or the Holloran behind your work is valuable. I would never have gotten my seminar through the curriculum committee if I hadn't had Carnegie's name on it. And finally, when you're doing new, unpopular, misunderstood work, reach out to people beyond your institution. All right, the next thing that happened to me is I went to a new school, Mercer University School of Law. I was hired as dean there. It was a school that was already doing work around what they were calling professionalism. We were not yet calling it professional identity. Being a dean, not as many people pay attention to what you say as you think they're going to, but people pay attention to what you see. So it gave me what you say. So it did give me a little bit of a platform. We had great collaboration within the law school and the university. During that same time, I was introduced to the Holloran Center, which we don't have time for me to talk about all the ways in which they've affected my growth. There was a group called the National Institute for Teaching Ethics and Professionalism. In fact, I think it was at one of those programs that I met Neil and Jerry. It was very important to my formation during that period, as was the Institute for Law Teaching. All right, so what lessons did I learn through this last 20 years of my career? Well, first of all, be positive in this message. I did not start off being positive. You all might have gotten a glimpse of that. I started off saying, look, horrible things are happening to lawyers, and it's because of law schools. So I don't want these horrible things to happen to you, so let's have some interventions. It's not a very welcome message, right? It's not welcome to other legal educators to accuse them of doing horrible things. It's not very welcome to the students. So we've learned that really what we're about is helping students to flourish and to lead meaningful lives. And that's really helped. I've learned from my work with and about Holloran how to teach professional identity formation, small groups, feedback, dialogue, reflection, and meeting students where they are. Still a challenge sometimes, but I hear Neil's voice in my head. I learned that ancient philosophy, what Aristotle said about virtue ethics, has been proved over and over again by modern social science. So more interdisciplinary work, bringing in things from outside of our field. I learned that what we're doing is not professionalism, it's professional identity formation. We can learn from the professionalism movement, but what we're doing is different. We're not about how to behave, we're about who someone is. I learned about the values to ground the professional identity work in values. I'm going to take just a moment or two of privilege, if I may. And I was privileged to be able to co-write a book. One of my co-authors, to whom I'm married, is here. One of my co-authors, to whom I'm not married, is not here. Collaboration around co-writing a book can be a challenge when you've never done it. But what happens is you get the best of everybody's work that comes out of it. And so we developed this definition, which I have grappled with through my career. What really is the definition of professional identity? It's not particularly pithy, but to me, it captures the work that we're trying to do. It's your sense of self and role as a professional. And the benefit is if you develop the right kind of professional identity, you can meet the goals of the profession and also live a very meaningful life with meaningful contributions. We focused in this book around 6 lawyer values. There are lots of ways to express the lawyer values, but the point is you're joining a profession. There are values that you need to take on as a lawyer, and you might notice one of the things that happened is I was able to get practical wisdom in as one of those values because of that work that had started years ago in that project. All right, so what did I learn? I learned the what. I've struggled with the scope of what's really included in professional identity, and the challenge is it's complex. I think it needs to be grounded in values, but it's more than values. It includes those skills, your individual traits, and your purpose in what you want to do is very important. And then finally, we've got to integrate that so that students can avoid the dissonance that so often happens between professional and personal and bring those together. It's a big task, and we're still trying to figure out how to do that. The why? Well, because if you can do this, if you can live your life consistently with your values, you can have a great life and make a meaningful contribution in the world. Joy is probably the best way to describe that. The what? The how? We've already seen reflection, connection, these kind of pedagogies that have been developed. All right, I want to take a moment to celebrate where we are. The future is bright, the present is bright. We have, and largely due to the work of the Holloran Center, we've created a whole academic field of professional identity formation that did not exist in 2007 when the Carnegie Report came out. That is a lot to be proud of. We have a community of scholars and practitioners who are doing this work around the country. We have a shared purpose around caring about the profession and our students and wanting both of them to thrive. We have a common teaching problem and the scholarship of teaching and learning vocabulary. How does legal education assist in forming the kinds of lawyers that we want? We have sections for ALS. Students may not realize the significance of this. None of these existed when I was first beginning. We didn't talk about teaching at our annual meetings, much less empirical work or balance and well-being. That was the successor to the humanizing legal education movement. And the leadership section now is doing work that's very consistent and supportive with professional identity. Professions paying attention to wellness in lots of ways that was not happening. We have an ABA standard, which is great. I'm going to skip that slide. We can talk about it later if you want to. I think there can be a risk of ticking the box that comes with standards. That may be a challenge that we face. All right, I was going to talk about the future. I've talked myself out of time, but I actually decided this morning I didn't have a lot to say about the future, except as you know, I think this is misattributed to Yogi Berra often, but predictions are hard, especially when they're about the future, right? And that's true, because if you had asked me 20 years ago where we would be today, I could not have foreseen all the wonderful work that has been done. So I think the future is very bright, and I think we're up for the challenge. Finally, let me just end with a moment of gratitude. I'm so grateful to have been on this journey. The best takeaway is that it is a joyful thing to be working with students around developing their lives, making a meaningful contribution, and enjoying the joy and satisfaction of this wonderful profession that we're a part of. So thank you. I owe somebody a couple of minutes.
I'd like to welcome up Benjamin Madison.
Ben, good morning. I've been at Holloran before and followed Daisy Floyd. That is really hard. Okay. I love you, Daisy. And I really have some of my greatest friends in legal academia are in this movement. That's the wonderful thing about it, is you develop friends who help each other. On an occasion like this, the temptation is to, for me at least, is to lead with accomplishments. I want to instead lead with what we got wrong. I say we because that guy over there, Nat Gant, raise your hand. He was with me most of the way. He's now at a new school. But we built at our school, and that's really the story you'll hear, is Nat and Ben building and then realizing that you need to have the rest of the school involved. And we realized that we had got it wrong at first. And I hope in this presentation to tell you the journey that helped us get to a point where I think we are able to reach students in formation, because I really did not get that it's formation that we're after, not just instruction. Okay, so what we started, Nat and I came to some early Holloran Center workshops out in the rural Minnesota somewhere, and it was beautiful. And we loved it. We were very excited. We went back to school, and we wanted everybody to do professional identity formation. And of course, we could do it in our classes, and we proposed a course, a required course in professional identity formation. And we got to pass the curriculum committee, and the faculty voted no. That was a blow. But for the next year, we did something simple. We talked to our colleagues in the hallways, in the offices, at lunch, about what professional identity formation is. See, part of the problem is back then, there wasn't a standard 303. You may still find it a problem explaining to your colleagues what professional identity formation. They get it mixed up with professionalism a lot, at least ours did. And once we explained it and why it mattered, and it fits with our school's mission closely, once we explained it, the vote the next year was yes. So we got the course. We had the course, but we needed a way to make it work. And that's the second part of my discussion, is what we learned about how to reach students. For years, the classroom felt like it was working. The papers were good. The discussion was engaging. But there was something missing. And the most important lessons we learned were not in writing about professional identity formation or the discussions. It was in how we changed how we asked students to engage with it. Consider one of the exercises that I use. A senior partner at a firm tells a junior associate, these privileged documents, well, we can hold them back under a general objection based on overly broad and burdensome. And if the other side wants them, we'll make her work for them. Now, a student sitting at her desk alone can figure out what the problem is with that and state what the ethical problem is and how she would deal with it. The problem is she's not in the room with the partner, and she's not engaging with the pressure of feeling difficult, perhaps not succeeding at her firm. So that was a problem that we needed to resolve. The turning point came with the reflection paper where we're reading it, and it was a hypo where, the client had asked the lawyer to serve the president at a public event to embarrass them. Who would do that? We gave that as, I think it was a pretty good hypo. And this student answered by saying she was torn. The student didn't say, I know how to handle this, or I know what the problem is. She was torn. That was the first time I had a student who admitted that she didn't know, that she felt a pull in different directions, and that she wasn't quite sure how to deal with it. Now, I reassured her that she was on exactly the right path, and it actually helped Nat and I start to see that there was something going on that we weren't aware of. And it really, Daisy referred to our own development. It's a funny thing about this process is you start professional identity formation, you start finding it working on you. And what in reflection, Neil Hamilton taught me reflection. I realized, and Nat agreed with me, that I had a tendency to want to encourage students, not to not make them feel uncomfortable. And that was getting in the way of formation. To do formation, the students have to feel the pressure, the felt pressure of either some powerful figure or someone in the scenario that they experience them being there with them. And whereas the answers to these problems had formerly been really technically correct, but morally uninhabited, they started to, as we work toward changing ourselves, our approach to teaching professional formation, we decided how to, and if I pause, it's because it was hard for me. I don't know why I want to encourage students so much, and why I couldn't want to make them feel uncomfortable. I'd felt uncomfortable as a lawyer. So, that's the way, that's formation. What we were doing was instruction. It wasn't formation. Formation is where they have ethical problem, and then they have the pressure. Robin Alton Sternlight and Psychology for Lawyers identified this problem. It's called the idealization problem, where it's a common tendency of not just lawyers, but many, to predict in the future one will act ethically and dramatically underestimate the situational pressure that affects the decision. And so that's what needed to come into our formation, is having the pressure there with the challenge and letting the students know it was okay to struggle and talking about how to resolve that. So, oh, by the way, I didn't mention this past year, as I'm retiring, I'm one of the retiring guys or gals. We get an extra credit out that we're going to be using. I've already prepared it for my successor for role plays and simulations that will engage in more formation. So the longer I've done this, the more time I've spent on formation. And that's one of, if you sense an argument in my presentation, that's one of the things I'm trying to pass on, is that what I learned is that you want to do formation, take a look at yourself. Are you getting in the way? I was. And we found a way to start engaging the students so that they were really learning to be formed in the sense that they wanted to be. Now, one of my approaches is also to name what's going on. And I would quote Professor Reed Elizabeth Loder's description of moral drift. Compromising one's values produces changes that are, quote, almost imperceptible. Incrementally, inauthenticity slips into a newly authentic lesser self. What we were doing in these when we started role plays was to make that process visible. We started having the students become aware of that pressure, and that they didn't, and to interrupt it, and then have them realize that they did not need to compromise their values, but that was what was at stake. Now, the third part of what I'll tell you on our journey was that, and probably the most important, and bear with me because you may not see it at first, but the long-term anchor, I believe, and Nat believes, is that it's purpose and discernment. What protects a lawyer at 2 a.m. when no law professor is watching 15 years after they've left law school, and the easy answer to solve their problem is right there? That developing a vocation and a sense of what your values are and what your purpose is, to me, is one of the greatest protections against compromising your moral compass. Our answer developed over years. We do a discernment plan. It's like the roadmap, in which the students go to a psychology and counseling center at our school, and they take personality tests, well-being tests, and they meet with the clinician there. Then they come and talk with the faculty mentor who stays with them throughout law school and really gets to know them. and help them in their process. And in that process of developing the discernment plan, and this is not something that's a one and done kind of thing. It's a living document that lasts throughout 3 years. This past week, our students turned in, our first year students just turned in their discernment plans. I'll read you a quote from one. I sense a call to serve others by upholding the integrity of the legal process. Whether advocating for the state or an individual, I believe my role is to use my gifts of organization and calm response to seek justice. My high degree of wellness and spirituality is my compass, and it provides the compassion that motivates me to see the legal profession as a way of service more rather than just a career. That student is not describing a job. That she is describing a vocation. She has connected her personality, her values, what the law is, what she's doing in the law together, and that forms a self that is harder to compromise. Hence, as I said, this is the ultimate protection for information, is developing that sense of who you are, why you're here, and why you won't compromise. For those who don't know already, Regent Law does seek to integrate Christian principles into teaching. But this, and St. Thomas certainly does as well, but it's, the mission has at times facilitated our students' search for a purpose, but this is central at any school. And the research bears that out. Krieger and Sheldon's work that Daisy referenced showed that lawyers across the profession found that values anchored in intrinsic values, a sense of meaning and purpose, reported dramatically greater well-being than those driven by external rewards. That's what we got wrong and what we learned. I think we're doing it better now than it took longer than I would like. And like I said, I got in the way, and I try to stay out of the way now. In closing, I'll say many in this room have been in this movement from near the beginning. Some of us are approaching the end of our teaching careers. It seems worth pausing on this 20th anniversary and to ask what we are leaving behind. We are leaving a movement that, against considerable inertia, has changed legal education. This center and the scholars in this room built the response. We are leaving a body of scholarship, a set of pedagogical principles, and generations of students who know that law is more than rules, that integrity is earned, and that purpose is not a luxury but a necessity. We're also leaving work unfinished. The next generation of this movement will need to press for depth, not just breadth, for simulation, not just discussion, for vocational discernment, not just career advising, for well-being integrated into formation, not just appended to it, for the whole institution, not just one course. I began by confessing that the papers that were confident were those that I thought were the ones that we were reaching. What I know now is that formation doesn't look like confidence. it looks like a student admitting she is torn and then finding a way to see that her values and her judgment don't have to be compromised. Thank you.
To finish up our first panel, I'd like to welcome up Neil Hamilton and Lou Billionis.
Thank you. Good morning, everyone. It's great to follow those two talks. Consider this a complete endorsement. And we didn't conspire, but I think it's a testament to all the work that's been done for so long that we will find ourselves so in tune. Neil and I are going to talk about the future. We approach this, we'll be writing this. It's a paper that's in the spirit of a strategic plan, but it won't be as dry and it'll be a lot more readable. And we hope actually more fulfillable than many strategic plans. But let me just leave you with two words that have dawned on me as I was listening this morning that may sum up what we may be trying to encourage. Two words of comprehensive and inclusive. Okay. What we see is that professional identity formation has gone mainstream. It's no longer knocking on the door. It's really very much spreading through law schools. And therefore, those who care deeply about it are going to be finding themselves increasingly engaged in conversations with people who are not the early adopters, not the intermediate adopters, but the more latecomers to it, along with new entrants to the field. We need, I think, to seize the opportunity to be very mindful of the communication challenges and opportunities presented there. We speak of professional identity formation in really two different ways. Daisy Floyd spoke of it, I think, especially in your capitulation, as a comprehensive theory of what a lawyer experiences from becoming not a lawyer to becoming a lawyer. You are not a formed lawyer. You don't have a professional identity as a lawyer if you're not thinking like one, if you don't talk like one, engage like one, communicate like one. Professional identity formation really is a comprehensive theory of what it means to become a lawyer, to educate oneself into a lawyer. Law schools do some of it, but a lot of that education comes in other experiences. The other way we use the phrase is as a call for reform and betterment in law schools. There are things we are neglecting about professional identity formation that need to be amplified or spotlighted, and that the entire process also needs to be named and understood. As we proceed, it's just going to be helpful in communicating with others to recognize that we use that phrase in more than one way, and to know which way you're using it when you're speaking with someone. If you're speaking of it as a comprehensive theory, you are embracing everyone in the room who's in the project of teaching students and helping students. If you're using it as a reform call, you're asking for resources, complaining about things that haven't been done, calling for new initiatives, and you will have a different conversation. And it may threaten some folks as non-inclusive and actually exclusive, or just redistributing resources and attention. That's where we'd start. Now, the strategic plan we foresee has 4 zones. Neil's going to talk about one that's of critical and vital importance, but I'd like to talk first about one zone of work that is about the field. It's true, a field's really formed. And a good bit of what we have to do ahead is continue to work the field. Just do the vital work that folks in this room are doing. People will stay with an innovation, and they will adopt it if they haven't yet. If it's useful and knowable and congenial to their world, if it is compatible with their values. So the research you do, the experiments you run, the publications you issue, the sharing you do with your colleagues, the meetings, the communing, all of that is building more and more content that will prove useful to people. And as long as we continue to do that work, the correctness of this project is just going to continue to propel it. Another dimension, though, and Ben spoke about it very well, about deepening, is that the research, the literature in medicine teaches us, or at least our friends in medicine teach us, that It won't be enough to just have this material out there and having general familiarity to truly fulfill its potential. It needs to be deepened into a shared mental model within the house. We don't have the time to talk about that today, but what we would suggest simply is to recognize that law schools are in a professional identity project of their own. And it takes nurturing, it takes the right professional development programming so that people can make this great content more and more their own. And that needs to be done consciously and with intentionality. We need also, though, to appreciate the particular difficulties that we're going to be facing around values. There are, as many people know in this room, folks who are cautious about conversations about values. Professors may think, well, that's too subjective. It's taking me into a space that is not my comfort zone. So they may be resistant or at least apprehensive. Others may see values as an area of contest and spirited discord. They may be challenging contemporary or conventional values as privileging some and excluding others. They may be they may be seeing ideological battles behind values. It's inevitable. And we are in our view of professional identities, it starts with values. What does one do when one encounters that kind of resistance? Well, I love it. You have to accept it. You have to hear it, not feel threatened by it. It may indeed sharpen our own focus about values that need to be understood better. It may focus us on values that are missing, value statements that are under-inclusive or, for that matter, over-inclusive. But most of all, we need to listen carefully and appreciate the conversations, untangle what may be an ideological morass, and seek clarification. We're living in times where that's likely to be very much the case. Discussions of rule of law these days, for instance, are all over the map and very much informed by pre-commitments and positions that require further explication. So we should foresee this and not see it as an attack on professional identity formation so much as a natural outgrowth of working in the right field. There are other topics in our zone, but and the rest of what we want to talk about is particular changes and challenges in the world that law schools are operating in. And Neil's going to take it up right now along the legal profession. Right?
Yeah, I am.
Okay.
Corey, can you help me out? We feel God's love is surrounding us. So I'm going to proceed from that foundation. And so much of God's providence is in the room. That was Daisy's talk and Ben's talk, how we all, in our discernment, right, of our purpose. All of the professors are in formation, as Ben just said, as well as all of our students. So, and here I turned 80 recently, and I'm completely in professional formation. Here we are, 56 years into this professional life, and that'll continue to the end of my physical time, no doubt about it. I want the journal editors to know you're part of a very important part in two ways. Number one, this is the 8th of the Law Journal's Symposia on professional identity formation. So you've been central to the creation of the scholarly field that we've been talking about. I mean, a lot of it is your work over these years. So we're so grateful for all of your work. And then, of course, you're our teachers throughout. That whole idea that I've published on many times about going where they are, well, actually, that's what Ben was just talking about. That comes from students. Where are you in your development? One of the wonders of the whole thing is I'm 2 generations away from you, but I get to see the world through your eyes. The various reflection papers that you write, the credos, the eulogies that you do for me. I mean, it's like completely energizing. It's like God's gift to me. And then this comment that Dean Kelly made about Uvi, my wife. So I'm telling her about all this agentic AI challenge coming down the road for us, for the profession, for legal ed, for you. And Uvi says this a couple months ago, as Dean Kelly said. Uvi said to me, well, I think the agentic AI augmented practice is going to be the catapult for professional identity formation. Those were her words. And that's what I want to talk about here. Why it is that, although the way the profession is talking about, by the way, I want to mention some of Bill Henderson's here. Bill's work from years ago was pointing out how much the profession has to accommodate and seize the opportunity is the language, right, of these changes. So, I mean, I'm building on a lot of what Bill has been saying. So, what I think is going to happen here is you'll see and there's two companion movements going on, well, 3 really. Artificial intelligence, I want to talk about, and how that is going to catapult professional identity and the mission of this law school and this community. How Next Gen Bar is actually going to help us in our movement. And I'm less knowledgeable, but the whole alternative pathways to licensure is another companion here, which I'm not going to talk about today, but I believe this afternoon we have speakers. We actually have speakers in other panels on AI today, and we have other speakers on Next Gen. But what I am hearing from all of our alums and from our people out there in the practice of law, they're trying to figure out, well, how agentic AI practice will change all the workflows. But foundation, well, what is it we're selling? What is it we're going to be selling to our clients when AI is increasingly able to do some of the basic work? Well, and then you start probing, well, so what is it they think they're going to be selling? Well, look at it. I mean, what they think we're going to be selling is the human-centered skills. Obviously, you've got to have AI. The faculty just passed a new requirement for 1 credit in LS2. That's an AI that you've got to have. I think you've got to have more than just 1 credit of AI. You're going to need to engage with this technology and learn how the technology partners into service to the client. That's what has to happen here on your watch. Well, I do things. I mean, on my watch, not over. I'm retiring. It's not over. I'm going to keep writing, but it's what really. Really, what we're talking about here is the next 60 years on your watch. So it's going to be about client relationships that build trust. It's going to be about client counseling, client-centered professional judgment, either human-centered advocacy. I mean, Daisy and Tim and Pat Longan have written a lot about judgment. We have people in the room who've written a lot about this. But what we need to do is move the scholarship specifically toward, well, what are these central, in my view, faith-informed skills? How do they specifically interface with agentic AI augmented practice? So that you see it's not over here is separate and it's not threatening. No, it's something that's going to accompany us and it's going to empower us and our clients. So that's where I think we want to go. So what the firms are asking, and this came across last evening with so many of my research assistants here over the years, they want law schools to partner with them to accelerate each person in this room's development of the human-centered skill that AI does not have. accelerate the development of the human-centered skills that AI does not have. This is urgent. As far as I can read, this is a prediction. Essentially, on a conservative estimate, we've got in a 3-year horizon a 5 to 10% decrease in law graduate employment nationally. That, if we follow what happened after the Great Recession, I'm an interim dean in 12 when the roof absolutely fell in on this law school. When Bill was nodding, I'm sure every professor in this room is nodding. I mean, applications just plummeted coming off the Great Recession in 12, 13, 14, 15. It had a devastating effect on the schools. We're still working our way out of it. But that would mean applications will go down 10 to 20%. In the Great Recession, the employment went down 13% nationally, okay, coming into by 13, 14, 15. Applications went down 28% nationally. Can you see? So, because the applicant pool is always about 2 years, 3 years behind the actual employment, right? It takes the applicant pool a little while to get it, that the employment situation is changing. So the point that Lou and I want to make here is this is urgent. This is not, let's wait for the usual, which is the case. I mean, you know, how to kill something, send it to committee. I'll send it to another committee. Somewhere out there, people will retire and nothing will happen. But anyway, what's going to happen here is the early adopters are going to have a tremendous advantage. And what I want for this school is us to be an early adopter. And I want us to be aggressive on that. And I mean, it's our calling. It is our calling. It is our time. That's what I want you to do with your colleagues. It's our time for this movement. Oddly, it's odd under the circumstance with so much worry and concern in the profession. But I think we have an answer. And then the next gen, I'll be very brief here. So here's the profession. Now we have the profession. The state Supreme Courts are telling us it's no longer enough to just teach thinking like a lawyer, legal research, legal writing, you know, trial advocacy. It's not enough. No. The clients, the society, the client counseling, violation, negotiation, investigation, but those are all, and then there's all, when you look at domain description, all of them say practical judgment is foundational. Practical judgment. Well, so these are the human-centered skills where we must go. Now, the next gen bar, the thing is, the faculty will react often well, as they do with the, well, actually they don't, with respect to the thinking like the lawyer skills. Because what we have to get you to pass the bar, right? Okay, you have to pass the bar. We have to help you get there. But would you not say, but what you're watching in the classroom, I'm thinking like a lawyer, you're watching levels of excellence. Okay? With your professors. You're watching them demonstrate to you what it looks like to be truly excellent at thinking like a lawyer, legal writing, advocacy skills, right? And then you would model on them, right? Raise your game, you get input from them. Okay. So, but with respect to, let's take client counseling. Well, that's complicated. That's very human-centered. And how are we going to assess it? How are we going to assess whether you're right at competence? That would be a bar level, but the bar is going to be testing you on a written format of all things. And can we actually test that client counseling on a written format? But we're trying. We'll keep trying. You will be experiencing it. It's really experiential. That's what that. I mean, how do you actually learn? How do you learn? I mean, all of you got 22 through 8-year-olds principally in this room on the student side. I mean, how are you learning the complexity of human development, your own development, your client's development, the team around you? I mean, it's experiential, isn't it? And you try it and then you're sorry, You're gonna.
I'm not in charge.
You're gonna learn it experientially, and you hope that you're gonna have mentors and coaches around who watch you, who give you feedback. If you don't, then you gotta start picking out recruit coaches too. My wife taught second grade Minneapolis history 24 years. My youngest daughter's talking now 18 years. They say in second grade you can see students who already know how to recruit adult attention to them to help them develop. See, but it's a learned skill. It is a learned skill. So I hope that makes sense to you. So the sooner you get it, you need to be proactive on seeking that kind of help. And of course, some of it's going to be negative. Some of it's going to be negative, but they're trying to help you. That's all I'm saying. I was so blessed providentially with some teachers who saw me, came by my side. Wow. I mean, what an astonishing blessing in life. So the next gen's going to test the floor of confidence with the milestone model that I just shared with you. I just wanted you to see, now this is an early stage model. Well, what would it look like if we actually were testing or would help you understand, well, what are the stages of client-centered problem solving and good judgment? Well, now I'm just tracking what the medical profession is 25 years in front of us, medical education. But here's this. I just want you to see what would it look like. I would say on the far left, in my next project here after we get through this academic year, is on the far left, I need to put in, well, how are the bar examiners going to define professional judgment, practical wisdom on the bar? See what I mean? I gotta show you how this next gen bar is going to define that skill for you at the threshold level, so you will be bar competent, right? But there's so many levels above that. I mean, it's lifelong process of learning good judgment. Coming alongside people and helping them and talking to them about any problems they have. Well, anyway, all I'm saying is so we're going to have to do this for client counseling for each of them, right? Client counseling, negotiation, all these human-centered skills. And then we're going to figure out a curriculum that actually does this. Helps you go stage by stage with evidence. Those people on here. One reason the employers struggle a bit with the clinic, clinics would be perfect. Of course they do this. Problem is everybody gets an A. So from an employer standpoint, well, isn't that interesting? How do I possibly distinguish between among all these students? Everybody's got an A in this course. I mean, so that's why the only way for you to prove it is, well, you've got people who've seen the work who come forward and say, I saw Mary do the work and she can do the work. I mean, she's really good. She knows about clients. She's reliable. So we're going to move toward portfolios, among other things. Anyway, I'm sorry, I went a little over time. Thank you for giving me
very quick. If you think about what law schools are going to be facing, they face an affordability challenge, as does higher ed. They're facing a trust challenge. I like the language from Yale's new study of the criticisms of higher education. Law schools are going to face the same thing, are facing the same things. I think it's self-evident that working a comprehensive theory of professional identity formation as the comprehensive theory of legal education answers these challenges, is responsive to them. And I'm not developed that now, but you can read about it. But it meets the value proposition of law schools very, very well. But think about what it may do to the mood in the house. And this is actually a tremendous opportunity for us. We have been talking about changing the culture of law schools as long as I have been participating in these kinds of conversations. Let's think for just a minute about what might leave some of our friends in law schools ill at ease. Some professors are feeling that their autonomy is being challenged. I am coming from Ohio, where the legislation that is challenging the autonomy of professors. Their sandboxes have been flipped upside down. That's a very uncomfortable experience. Some are feeling less in the loop than ever. As law school activities expand, the curriculum expands, as the personnel variegates, more and more people in the house with more and more new titles that they don't recognize. Some are going to feel that their own worth is being challenged, not appreciated, disturbed, if you will. Talked about comprehensiveness. This is about inclusiveness. Professional identity formation actually can really help here if we accent the profession for a moment and not the identity of individuals. Professional identity, as we talk about it, contemplates that everyone in the profession is contributing service. The profession collectively must serve. It's going to require the best lawyers that we can produce individually, who are as formed as they can be. But the profession collectively needs even more than that to serve. It needs vital legal scholarship. It does. And its absence makes the role of an individual with professional identity as a lawyer quite different. We can't change law for the better. We can't make access to law more readily available to people. We need to remember this, I think, as we talk with our colleagues in this next stage of development. We say that everyone's in the business of formation, and they are, but we're also very much all in the business of wanting to see a legal profession that has all the tools it needs to serve. I think what has happened with the development of changed personnel in law schools and enrichment of curriculum and all the work that's been done by people in this room is that we can do more of all that we want to do more efficiently than we ever could before. And that's one of the subtle outgrowths of this movement that I think is going to sustain it in the future. Thanks very much.
Thank you, Professor Floyd, Professor Hamilton, Professor Bilionis, and Professor Madison. I'd like to open up the floor for questions.
Okay. So a common theme in these presentations that I heard was like putting one's own morals kind of at the forefront. And something that I'm wondering is, so when we're doing that, how do we address and balance and move forward when people's morals that they're putting at the forefront are conflicting? The speakers don't have to address this context. I just want, like, kind of where I'm coming from with this is like, this is a problem that I come across as a trans student at a Catholic law school. So I'm kind of wondering if you have any insight on how to go about that.
I'll take it.
Oh, yeah.
Well, complex question, challenging. Okay, we were talking about the values propositions, right? The various systems that we're in. The way we've approached it, given that our society has a lot of diversity of values, right? True in the room that we each bring. The way our present approach is that, well, our profession actually decided on some core values. Those of you that have taken PR, professional responsibility, I mean, you know that the way to set up, I mean, you've got the floor construct throughout the rule systems, right? Diligence, confidentiality, right? Competence, those are floor, though. We'll set that up, below which we'll discipline. But in each of them, although the rules don't talk about it much, would you say there's a whole range of excellence in each of them? Okay, so there's sort of foundational. The preamble has values. I mean, at least at nearly all schools, I'm guessing you teach it differently, but the way that people normally teach PR is very rules-based. What we're asking you then is, each new entrant, you have to internalize these core values of the profession. We've agreed. Why am I saying, at least for now, you can actually change them. On your watch, you can change them. Everybody see how that's going to work? You'll be a licensed lawyer soon, and you have a vote as to how we change these rules. I mean, I used to tell my students at Mitchell, because they wanted to change the rules. Okay, so in Minnesota, what we've got to do is we're going to bring it when the annual Minnesota State Bar Conference is in Duluth. Why would that be? A smaller number of people going to Duluth than when the annual meeting is here in Minneapolis. So then we're going to get our 200 people into that meeting, and we're going to have a majority. I think a little bit strategically here. You can see, though, we can change these values. I think the profession, I'm sure your experience is the profession is struggling in here with the trans issues and trying to figure it out. I don't know if I really answered your question, except from our standpoint is trying to lead the movement. Our profession, the medical profession, they all have addressed the values issues together, and at least we need to look at that, right? Because the profession is asking you to internalize those values, and then you want to change them. Well, that's what this whole movement is about. So you can do it. It's just going to take perseverance, grit, maybe needed.
So appreciated and agreed with Lou and Neil on their presentation, especially how professional formation and AI and some of these new technologies can be complementary. I think my question is for Daisy, actually, although others should feel free to jump in. I thought it was very helpful that you set kind of the historical context and background in terms of how professional formation and professional identity formation developed. I'm curious whether there's been any conversation between another literature or another movement that I think was emerging at about the same time, or at least in the 90s and 2000s, which is the movement about social norms. So I'm thinking here like Bob Ellickson's work, Shasta County, the idea that yes, law is important and plays a role, but when you look out in the real world, and I'm saying real world outside of law school, lots of people are organizing their behavior based on social norms, even independent of what the actual legal rules are. And I sort of say that because within law schools, law professors, law students, lawyers, law deans, we're very focused on the law. I mean, every class period is based on cases, and obviously it would be a statement kind of against all of our interests if we were like, well, the law is actually not that important or not as important as you might think. But the reason why I think it might be very complementary to professional formation, because in professional formation, we're thinking about who should lawyers be, how are we developing lawyers? Given that lawyers are serving clients and are counselors, if those clients, and obviously there's exceptions, in tax law, we're very like, what are the legal rules? But in lots of other areas, if the clients, and this kind of goes to table one in the handout that Lou and Neil gave, it's all client competencies. If clients in large swaths of areas are actually being driven by social norms and not law, is that movement in conversation with professional identity formation at all? Or could it be going forward? Because I do think the social norms and what clients are doing might play an important role in terms of how we're training lawyers.
I'm not aware of specific conversations going on, but yes, I certainly think that's relevant. And I do think one failing that we have is we think what we do here is the whole picture. I mean, some of that comes from we're academics, lawyers, it's, what we do here is all that matters. But certainly, I think we will reference this, that there's a lot of formation that goes on that's not in our control, and we're trying to prepare our students for continued formation that's going to happen as they grow other lives, and they are encountering other norms or other values that don't respect the things that we can still live with. I don't know if all conversations some others might. I certainly think it's relevant. Important.
And I think what I'm hoping to do in the next few years is right. And I think what I want to join is the national conversation on values. Because we're just part of this country is in trouble. That's my personal view. And we're in trouble on values. And, one problem that I have not been doing that, sweeping that into the national, we talked about David Brooks, or no, that was history last night. Talked about David Brooks, what a great book. But okay, the problem is when I go into that, which I've not been doing, is I'm going to get condemned, because I am going to speak about values. I'm going to get condemned by the far left, I mean, the postmodern. You know what? There are no values. This is just a white male for speaking of values. And then I'm going to get condemned by the Trumpian side that this is somehow an indirect attack on the president. So, I mean, it's going to be kind of a no-win deal here in that space, but that's just my view. We've got to embrace that literature of what is happening in the forums. I think that's what your question is about, man. So.
Fantastic conversation. Daisy, it was really interesting to hear about you walking into these waters in leading your day, and I was met Neil and Jerry fairly early on, and stuff that was going on at the Holloran Center, and I want to make a suggestion for maybe a kind of a follow-up research. Maybe you've already started it, but these first cohort of these students are probably what, 45 now, 46, 47. And we're past our odometers way ahead of that. Yeah. But we have students now that are part of the journey. We really need to follow up with those folks and to have a three-way conversation. Bring a student along. We show up. We talk to our former students, and I think that some of these value issues and some of these tensions, because they've lived half of their professional life, they've got another 20 years ahead. And I think it would be a really just that compendium of just these simple narratives. Looking at the themes here would be a really profoundly powerful refresh. And I can't think of anything more relevant than anything that connects the whole thread, together. You've been, I feel like one of the best things I'm able to do is stay in touch with my former students. And can you give a couple of examples of, and also Ben, have some examples of students that we've stayed in touch with, and it would be fertile ground for maybe.
Yeah, I mean, I think they're out there. I don't have plans to do some kind of formal project, but I think that would be fabulous. And you do hear from students, of course, who will contact you and say this really made a difference, or they'll write you and they'll come back, but that's not any kind of formal way of measuring it. And I'm thinking based on. Our experience was like Ben's, and we didn't do it very well at first, I think. And our Mercer experience, many of you have heard us talk about. And so it would be also interesting to compare kind of as we thought we were getting better about doing this, did that seem to change the effect on students? What we hope we're doing, of course, is planting seeds that allow them to continue the development of their formation. And so a lot will happen since they've left us. But
one suggestion I have is I recently did a project where I created these structured questionnaires and sent these students out to 7 county area to interview lawyers and judges. And I realized that I got way better data because it was these young people with these bright eyes, and they were being poured into. And if I had been in the room, I would have ruined everything. And I think it would be a profoundly positive experience for the students. It's frees on the data collection once we can kind of get access to this stuff.
I think it's a fabulous idea. I love that. We do in our first year course at Mercer require them to do an oral history interview with a local lawyer. And so as you're talking, I'm remembering some of those are our graduates who do talk to them about the effect, of the education. So, yeah, I love that. I love that idea.
Thank you to our panelists. Thank you for questions. We're going to take a 10-minute break.
Our moderator for our second panel is Rebecca Stokes.
Hi, everyone. I'm Rebecca. I'll be moderating this next panel. We're going to have Megan Bess, Associate Professor of Law and Director of the Externship Program at the University of Illinois Chicago School of Law, and Susan Brooks, Professor of Law at Drexel University's Thomas R. Klein School of Law, and Tim Floyd, Professor at Mercer University School of Law.
Hello, thank you all so much for being here. I'm just so completely honored to be included in such a great event among so many people that I have looked up to for so long in my legal career. And I'm also really excited there's some students here today because I'm going to talk about students and things our students have told me. So maybe you can all chime in and let me know if in your experience, the data I have gets it right. Okay. They're like, great interactivity, just what we were hoping for on a Saturday. So what I'm doing here is I'm going to share some data that I've been collecting from a 2-year study, and I'm actually now in my 3rd year of collecting data from our graduating students at the University of Illinois, Chicago, trying to ask them about the impact of different experiences on their professional identity formation, right? And I did this as a backdrop against, the standard 303. It's new, it's sort of new, it's not even really that new at this point, where we have to give our students substantial opportunities for professional identity formation. I sort of come back to the when and how. I don't want it to be a check the box thing, right? And I do think that, schools have a lot. That ABA questionnaire, man, we just did our site visit. You want to check as many boxes as you can. But to really think a little more intentionally about when and how should we be doing this? And yeah, maybe we checked the box when we first had to have the plan, but did we take it away? So I wanted to ask students about the impact of different things. And this, of course, I am very much a Neil Hamilton fan. No surprise there. I cite him a lot, and I was really inspired by some of the work that he did, asking students at this law school about their 1L experiences and what was most impactful there. So and he actually made some suggestions at the end of that article that somebody should do more research. We should talk about all of law school. We should talk about other, things that students do, especially in the 2L and 3L year. And also building on Neil's work regarding major transitions, sort of what is most impactful and what really helps is a major transition in the path from student to lawyer. So I designed a research study. I had to learn how to do human subjects research and get qualified to do that. That was a whole adventure just to get IRB exemption. But wow, I have so much respect for people who do a lot of research. But it was also really fun. As I designed it, though, I focused a lot on right? I wanted to know sort of based on my hypothesis that, real world experiences, it also simulated real world experiences would probably be the most impactful. I built this based on some other data. There were some great NALP Foundation studies back in 2010 and 2011 about attorneys who were a few years out school, and they rated clinic and externship experiences at that point as having actually looking back been very impactful on their development. CSAIL data has continued to show at a lot of law schools an increase sort of in demand for externship in clinics. So if students are asking for more of it, more, that seems like something that's probably impacting you. So my goal was really with all of this was to gather data about the impact so that we can really improve both the access to these opportunities for students and the support that we give you in the professional identity formation during them, right? If we know that these are important to you, but they also might be accompanied by a certain amount of stress, and sometimes it's just, it's a lot. You're going through this process of socialization. Should we be doing more to support you in these opportunities? So most impactful to, still impactful, but less so. This is probably not surprising to anybody, but legal employment outside the building, right? Working not in an externship or a clinic, but somewhere outside the building, particularly over the summer, but then also during 2L, 3L year. I will say, the summer after 3L year, we have a big part-time program. So I wanted to encompass realizing some of our part-time students actually do have 3 full summers of law school. So for some of them, their big experience might have been not after 2L, but after 3L year. Real world work continued to be most impactful. Again, this was across 2 years. The 3rd year of data is looking pretty similar. I also found something really interesting that summer experiences tended to rank higher than their during the year counterpart. So I see some nodding. Does that make sense, law students? Is summer really impactful to you? Raise your hand if doing something during the summer you think was really impactful. Yes, right? More so than doing it during the school year. Is that just because we're juggling so much during the school year, it doesn't get it maybe the full focus that you can give something in the summer? maybe I should do some different research sessions, some focus groups to really dig into why. I think at the end of the day, I will say I was left maybe with more questions than answers by all this data, but ideas to continue to dig. So as you can see, I won't read you all the data. This was sort of, I thought interesting. Pro bono work was impactful. An attorney mentor. I know you have an excellent mentor externship program at this school. Working with that mentor, if students did have one, seemed to be really impactful. Faculty, to the extent you have research assistants, that's actually really important to them too. You have a great opportunity there. And then we kind of went down from there. Orientation, I felt bad showing this to our dean of students, ranked last, but that's okay. It doesn't mean it wasn't important, but when we look back, think that you've come so far from that, right? So maybe at the time, and also you needed to know, like how to get in the building, how to sign up for this or that. But this is sort of how it broke down. I did leadership positions in student organizations, journal membership, authoring things, moot court mock trial, all of that. I also kind of separated it out a bit. We had activities where I just had fewer students and I didn't feel as secure in the data, although these all still seem, a lot of it was like repeat clinic and externship. And we have something restorative justice. It's a very specific type of externship type practicum thing, but still very impactful. I also went ahead and used some of Neil's methodology when we're talking about moderate, great, or substantial impacts. So percentage of respondents who ranked the experiences 3, 4, or 5. So that part of the scale. There were some unique things. So 100% for repeat externships, faculty research assistants, and summer employment after 2L, 3L, and really high on some of these other areas as well. So these things, very impactful. Students, as you look at this, is any of it surprising to you, or does it seem about what you would expect? Kind of what you would expect? Is it surprising to anyone? To me, I was actually really excited about that, right? It's a smaller group of students than I wish it would be, at least at my school. I always wish we had more funding for research assistants, but I thought it was really cool. And I have more questions. I wonder if it's really about the relationship, and that impact it has. And looking back, well, I got to know, so-and-so. In fact, I think Professor Brooks is here. One of my best friends in law school was her research assistant, Katie Cronin now. And she still is like, oh my gosh, she's so great. I remember being her research assistant. Well, she's a very excellent lawyer, by the way. So great job. You obviously formed her into something great. And then also, again, a lot of our experiential stuff also ranks still in the 80 to 89 percentile. So I also broke down the data a bit by type of students. So our part-time students tended to have some higher than average scores for different categories and lower than average for journals or holding leadership positions. I have a lot more questions and I would love to further break down data because I started to think as I was seeing this, we might need to adjust our professional identity mission efforts and focus for our different student groups, right? Part-time students are coming in, well, first of all, a lot of them already work and they probably already have a professional identity in the profession they're working in, right? So they're still integrating that with their new professional identity as a lawyer. There's some different needs there. And I think we need to recognize that. And if any schools have a part-time program, I've noticed one thing that happened with ours is they don't like to feel that we don't understand their unique needs. They want us to understand that they are already professionals with good life experience coming in the building, and the way that we treat them and the way we cater programs to them should reflect that, right? That's sort of like we're the grown-ups in the building. We already kind of know what we're doing. We're here, we're serious. So I think, that's part of a larger conversation regarding part-time programs. Working students, and this often correlated to part-time program enrollment, but not always. I don't know how our working students do this, but some of them still go in the full-time program. Similar with journal and leadership position ranking a little lower, finals, appellate advocacy. But, again, the working students might have some different needs. So I think it's really important when we talk about using this data or how we're going to tailor programming that we take into account these different student groups. And I will say also, my data is probably also highly reflective of the culture at my school. Right. So I think there are trends to draw here, but I think it could be something that I would encourage other schools to do as well, because what what things in your own school's culture are important to the students, right? Like our appellate advocacy course is this really where students really go through it in that class. It's a really intensive workload. And I think that's really important and why some of them, generally see it as important in their formation. Maybe it's not the same in other schools, but I did think that, the data, again, just more questions here. So non-working students, unsurprisingly, just the opposite. They found that leadership positions and journal experience were really impactful to them, maybe because they were looking for that extra, something to get outside of the classroom to really continue to build their skill set. Makes sense. For some reason, lower than average for drafting. I have this theory that more of our part-time students are actually interested in transactional work and really highly value like the contract drafting or document drafting, like non-litigation document drafting courses. Whereas the non-working students, who are in law school full time, maybe closer to have just gotten out of undergrad, think they want to be litigators. I mean, that's what I thought. And lo and behold, I did not love it. So some takeaways. And also a challenge, I think. Outside work is really impactful on students, of course, when they're not in the building, when we can't support them. It doesn't mean that there is no way to do it, but there's certainly challenges there. When you are all out in the real world, you probably don't want to hear from us quite as much, right? But are there ways that we can help you sort of reflect back on that experience, think about your skills, think about your goals and how it fits into your socialization as a lawyer, even as it's concluded, or even checking in and helping you to think about this stuff before you go, right? And I know you just want to get away from us. Like, let me go do the real work. I don't want my professor to call me. I don't want my professor to be involved in this. But we think that we could probably give you at least some helpful context to make it really meaningful to you. Experiential learning is really important. I am a clinical educator, right? So I was, of course, coming into it with that mindset. But it's really important that we make sure students have adequate access to experiential learning opportunities, and not just access to them, but that they are ratioed properly so that, faculty can develop those close working relationships with students. Because I think that's, again, part of the reason it's so impactful. Think about the way you would work really closely with a faculty member in a clinic, right? That's a little bit different, unique relationship than maybe in a doctrinal course, or even in a small seminar course. I teach a seminar course of 20 students. I get to know all of them really well. Still very different than when you're working together toward a common goal. So I think, this is, I put the data together in hopes of convincing my school of some things that I wanted to see happen regarding our experiential learning program and access to it for students. And I think others could do the same. I'm a big fan of gathering data also to advocate for things that you want in your own institutions, but also more than anything, and again, this should come as no surprise, that relationships are really important to students, right? And having opportunities to form relationships with each other, with other people in the building, with attorneys, with faculty, are going to be very impactful for students on their professional identity formation journey. So students, any takeaways from this? Did it resonate? Did I miss anything? Anything else that was really impactful to any of you that I didn't ask my students about? Or like, gosh, you should have asked about that. Yeah.
I wonder if you could, instead of just splitting working students part-time and non-part-time, if you were to divide it from a right out of undergrad to second career, some of those, or family situations.
Yeah.
I feel very different than my classmates. I worked before and I have 2 kids.
Yeah.
Very different than Zach here, who is 23, out of undergrad.
Yeah, no, I think I agree. And I hear that anecdotally from our students all the time, right? You are in the same law school and you are having very different law school experiences. And that's okay. That's a great suggestion, actually. Yeah.
I think kind of in a similar vein, I think it would be interesting to know how specific summer jobs impact it.
Different types of summer positions.
I in criminal public defense my 1L summer, and I feel like that experience, while both impactful, like very different from my peers who worked in a firm and were doing research all
Absolutely.
summer. Yeah.
You're right. The type of work environment really might matter. Awesome. Yeah.
I was actually going to say something very similar to what Corey said, because I'm also a non-traditional student. I had a career before coming to law school. But building into that, you talked about relationships. And I think building relationships among other students is equally important.
Yep.
My 1L year, I had a very hard time building relationships with my classmates because, again, I'm 32 and had a career, and my classmates are 22, fresh out of undergrad. And finding that connection was very difficult. And I would have appreciated if there was something within the school to better connect the non-traditional students.
That was a great point. Faculty, administrators, let's listen to the wisdom. Well, I think students have so much to offer us, right? When we listen. I will say also, I find that my students who work before, my non-traditional students, I love them in the classroom. I almost in some ways feel that they are partners, right? I teach legal ethics, I teach a leadership course, and even in my externship courses, I feel like I can sort of say like, well, what about your experiences? Like, do you have anything to share based on your professional work? And they really are able to contribute in a different way, right? So thank you for being brave enough to go to law school after having another career, or crazy enough, should we say. I hope you're getting something out of it. Anything else to add? Yeah.
I'm curious about the degree to which experiences either confirmed or contradicted students' pre-existing conceptions of
so like,
themselves.
what did you think coming in? Like,
exactly.
Oh my God, trial ad is going to be where it just all happens 100%. For me. And then you're like, it was fine. Mid, as my kids would say. They actually get really embarrassed when I'll tell them I use that in a presentation. Like, stop trying to talk like us, Mom. It's so embarrassing. But I think that is such a great idea. Sort of coming in almost at the orientation, like, what do you think is going to matter to you? Or is it going to be that paper chase moment where the professor calls on you and you don't know what you're saying versus what you actually think coming out? Great idea. See, more research to be done. If anybody's interested in doing this work, there's a million questions that we could be asking. Thank you all for offering me suggestions and ideas. This is really helpful because this will be my last year of data of this particular data set, because I'll feel confident sort of drawing conclusions from it. But then probably for the article I'm going to write for your journal, a whole list of other questions that we should ask next. And I did a version of this presentation for my faculty, and I had to leave the Lou quote in because I think it's so... it's just so true that, the thinking about all of this and having all of us here in this room today thinking about this, it really is the best sort of way to think about the future of legal education, I think, in a positive, hopeful way, right? In a unifying principle. I'm still trying to get my own faculty to see it as that, but I hoped the Lou quote would help. So thanks for saying that. All right. Thank you all so much.
All right. Well, good morning, everyone.
Good morning.
So I haven't been thinking my way, so I'm going to just invite everybody to go into a long thing. But just take a moment, maybe allow yourself to arrive more fully in this moment. Maybe just take a few intentional breaths. I know I need one now. On myself a little. And so just want to kind of do a very quick sort of form of check-in here. So just around the room, kind of check in with yourself, how you're feeling. Can I see like a thumbs up if you're feeling really like present? I'm here, I'm excited to be here. Thumbs up, okay. And then anybody that's kind of woke up a little bit rough this morning is all welcome. And, or could even be a little bit, I'm draggy, but I'm here. All welcome. Anybody. Well, I saw a lot of thumbs up, that's all. So I want to first, as I'm arriving more fully, just really thank you all. Thank the Law Review. Thank the Holloran Center, Neil, Jerry, David, everybody that I feel like this has been just a wonderful, beautiful community for me that has supported the work that I have done, which, speaking of, having prior careers, I came into teaching law, having been trained in field social work and practiced social work for a few years. And so, I kind of reached a very big disorienting moment, shortly after law school when I was working in a law firm, and I won't tell you that story. I didn't write it up somewhere else, but, where I was like, what? What was I thinking? This can't be my life. And I eventually found my way into teaching, found my way into being able to do work as a law professor that really felt more aligned with who I am, who I want to be as a human being. And so for me, the invitation here sparked for me a little bit of a kind of reflection on my own career and what are some of my lessons learned, like a little bit of a distillation of my own takeaways. The sort of inspiration for this talk and paper was a podcast. I don't know how many of you, anybody else listen to a lot of podcasts? Yeah. So this was a podcast series that Dr. Brene Brown did actually in 2024. And it was called Living Beyond Human Scale. So I'm going to tell you a little bit about where this idea of like kind of human scale and what that looks like. And I love that, Neil, we didn't confirm, but human-centered, that's language that's in this presentation. So I'm going to talk about kind of what is human-centered legal education? What does that look like? And I agree with all the speakers that have said that, you know, I'm not here to diss AI. I think it's an and, like a lot of things. And with AI, with so many things that are coming at us, and I feel like it is a little bit of that feeling these days, that being grounded, sort of like really focusing on being embodied in the work that we're doing is all the more important. So and then I'm going to try to give you a couple of examples of what that. So, okay, whoops. So the story behind this idea of living beyond human scale had to do with Brene Brown at the hairdresser with foils in her hair and working on a computer and also on her phone. And her stylist saying, you know, it looks like you're trying to live beyond human scale. She's like, well, what do you mean? And he told this story about, you know, being trained as a pilot and starting out in his training in a two-seater plane. And while he was doing that kind of piloting, it all felt like it was at human scale. He could see the ground, he could see the controls. Everything felt very, you know, kind of manageable, and he was in his body and he could do it. And then, you know, eventually he got pushed to pilot a jet. And as soon as he got into the seat of piloting a jet, suddenly it was all this like way beyond human scale. And the way that he had to activate, you know, like, or you know, be able to harness his thinking and his brain, it was everything was happening so fast. And you had to be thinking so far out because you're moving so fast through space. And so, I think there is a sense, for me anyway, that in this moment, with everything that's been going on in the world, and maybe even more so now than in 2024, there's this kind of, and again, you know, using the we, but it's a quote from her, and I don't know how many of you identify with this, but I think that there is a sense of feeling untethered. And I know for me, part of that is I have retired. And so I think I do feel a little untethered because of that. But I think there's another way that all of the stuff that's coming at us with social media and technology and world events and climate change and, you know, just horrible natural disasters and wars, it's very untethering. It's very disorienting. And so, you know, I think for me, it means it calls on us, and I think going back to kind of what Neil was saying, that as all of this is happening, you know, we need to double down in a way or redouble our efforts at this kind of human-centered enterprise of life and of legal education, I would say. So, you know, in this interview, she talks about, well, what are actually the skills that we're going to need? And of course, she's talking, you know, much more broadly than professional education or legal education, of course. But, you know, she says it's probably about neuroplasticity. I don't know if that means anything to anybody here. I'll come back to that in a minute. But this idea of really being in our bodies to understand how our nervous systems operate and how much we can take and not take. Right? And we're going to have to learn better how to regulate emotion. So when I read that, I was like, okay, great. Because this is the stuff that I feel like this has been my sort of area of what I've tried to bring into law teaching, bring into legal education. And, you know, if you want to talk about swimming upstream, I mean, really, whoa, way wacky, right? But like the longer I taught, the more I felt like this is what we need to be bringing to the classroom, to our students. And if we're not doing this, none of the rest of it actually lands or sinks in or stays with any of us. So I want to talk a little bit about this idea of what I've written about previously as a kind of like healing centered approach, right? Lawyers as healers, right? Lawyers as, you know, not as therapists, but as doing work that improves the well-being of clients and of others and their communities, right? And then also, as we do that, improves our own well-being. So I've kind of written about this in lots of different ways, but this is sort of my latest distillation of it, is really trying to come up with kind of three kind of buckets, three core elements. And so I'm going to talk to you about these three. So the first one is this idea of bringing a contextualized, multi-dimensional lens. So the first thing is context, right? Because when I learned law, and even when I worked as a lawyer in a law firm, I was talking to somebody about this yesterday. It's like I would get an assignment and I would have no idea what the context was, what the case was about, like any of the facts. And I would be like sent off to the library to try to do research. And I felt completely like at sea, like there was no way I was going to do good work because nobody gave me the context. So I feel like the first piece of it is we all need to appreciate the importance of context, both for ourselves and for our clients, for the work that we're doing. We need to like spend the time to understand and for each other, you know, in terms of so many aspects. So that's why I sort of came up with this, you know, multi-dimensional, right? Because I love this quote about like, I contain multitudes, right? Like we often will focus or land on one identity, but the truth is we all have these multiple identities and our clients do too. And, you know, our time horizon for various things can be very different. You know, I can be in a conversation with you and I'm in this moment having this conversation and you are 20 years ago when you offended me, when you said X and Y, right? So like, how do we bring ourselves to really appreciate the context that we're bringing into the present moment? And that requires an understanding of history and culture and politics and spirituality, right? And the importance of all these things. So I had 20 minutes and I'm already over using my time. So I'm gonna have to breeze through a lot of this. So another way to think about context that I've written about is this idea of personal, interpersonal, and systemic. And I found this really useful, I think, also in my teaching. And the basic premise is how I am with myself affects how I am with another person interpersonally. And all of those interpersonal interactions have ripple effects. And so, you know, what it comes down to is that, you know, my being focused in some ways or spending time or devoting some of my learning to cultivating self-awareness is not selfish, it's not navel-gazing, it's not self-indulgent. It's actually critical to me being able to be effective in the work that I'm doing with other people and in the world. So, I mean, I could, you know, hopefully we'll talk more about all of these as the day goes on or as this session goes on. So the second component for me that has been so central, and you've heard it already like half a dozen times at least this morning, is relationship and bringing what I think of as a relational worldview. Okay, I used to talk about, and I still do, relational lawyering, but really this is about real understanding that we're all constantly in relationship. And we have a profession that focuses very much on individual rights and an individualistic like kind of standpoint. And there's a disconnect there because none of us functions in the world in that sort of individualistic way. So I've talked about this idea of relational lawyering and how sort of core to that is kind of focusing a posture of what are we doing as lawyers, right? We can think about our work as lawyers as how do I protect myself from you or any of you, anybody. Not anybody. I'm not mean to look at anybody. But you know, how do we protect ourselves from the other that is undoubtedly going to try to take advantage of us, right? Like we can approach contracts that way, and we usually do. Somebody's going to breach this contract, so I'm going to think about all the possible ways that they're going to try to screw me over and avoid that by writing them into the contract. Or we could actually write a contract based on our shared values. We could sit down, and there is a movement called, you know, conscious contracting, where we start by, you know, the person who I'm negotiating the contract with, identify what are my core values? What are the values that I'm bringing into this contract? What are the goals that we have? And then write the contract from that perspective. That's a relational approach. And so the idea of centering relationships in all that we do. And I love this work of this Adrienne Marie Brown, who is somebody who writes about social movements, but she's identified these kind of principles, I guess, and they're also practices that I think apply very much at all these levels of personal, interpersonal, and systemic. And so I'm going to spend a moment just walking you through them, and then hopefully I still have a minute, I don't know, for examples. But, you know, I think this idea of presence, of slowing down, and we talk about slowing down sort of separately, but all these things are interconnected. You know, one thing that I've noticed since retiring from teaching is that I feel like I'm more present in my life. Like I have fewer, you know, the mind chatter that we all constantly have, like I have less of that going on, I guess less of that kind of noise. And I think it's never going to go away, right? Like I don't think even people who meditate for decades will tell you that it doesn't stop. It's not about trying to make it stop. It's actually about being aware so that I can, you know, be able to still be as present as possible in my life. This is a quote from Adrienne Marie Brown, which she talks about this idea of moving at the speed of trust, which I think is a beautiful kind of mantra for working with clients, right? It's like thinking about, and not just with clients, but, you know, with each other. Like, oh, good. Give me my 5-minute signal. Okay. So this notion of fractals might be a weird, strange word. It certainly was for me, but it's something that's taken a lot of her work. She talks about this idea of biomimicry, which is imitating the natural processes that happen, you know, like in the natural world. And one of them is this idea of fractals, which are the patterns that replicate themselves in nature. And some of you have seen those kind of wonderful documentaries about mushrooms and the mycelium, you know, network. So this idea that what I practice at the small scale actually sets the patterns for the larger system. So that's that interpersonal, you know, personal, interpersonal, systemic. So how I am with you, like me taking the extra moment to just make eye contact with somebody, say hello, ask about their day, but actually wait for the answer. You know, those kinds of things, like these little things. And I tell my students, I taught clinic for so many years, and it's so hard. Like the issues are so overwhelming. So how can I, you know, actually like respect, honor that these small interactions that I have with people, small acts of kindness really do matter. And I think even if I can't solve somebody's legal situation, me treating them with dignity, with kindness, with care, it makes a huge difference to people. I know some of you might not actually, like you might hear it and think, yeah, but, and I want you to hear it because it's actually been shown empirically, right? There's a whole field of procedural justice, procedural fairness that has studied that people, their experiences with judges and other parts of the legal system, whether they feel like they've had a positive experience, is not based on whether they win or lose. I mean, they want to win, of course, but it's more, or it's just as important, if not more important, how they feel like they've been treated. And studies have shown this, right? Jerry and I did a study with Mike. Well, it was his study. Maybe it was Clark's study. But we did it with this group of 1L students, and they asked family members, friends about their experiences with lawyers and whether they had been positive or not, and what had contributed to them being, you know, one or the other. And it was all about, did I feel listened to? Did they call me back in a timely way? Those sorts of things. So that's this idea of fractal. Okay, so I want to talk about the other AI, which is really, I think I jumped over a slide, which the third component of this is really what I think of as a strengths orientation. So we are so oriented, socialized, and specifically in the legal profession to look at risk, right? To look at the negative aspects. Our brains actually attach to negative information more easily than positive information. So we have to be really intentional about focusing on strengths and seeing the positive. And so there's a whole field that actually was called AI before what we now think of as AI, that's called appreciative inquiry. And it's a philosophical shift. I mean, it's also a set of practices, but it's rather than talking only about what's broken or what's the problem and how do we fix it, what's working and how can we do more of it? So think about how that would reorient our work if we focused on it in that way. And these are kind of the principles. A lot of it is about storytelling and bringing genuine curiosity and honoring that stories are substantive, right? We learn so much from stories. All right, so I wanted to give you some classroom examples. I'm sort of out of time, but I want to just at least I'll show you this one because this is the tool that I have found most useful in my own life, in my teaching, in community workshops I've led. And we've sort of played with it a little this morning, right? Somebody, Ben, I think, was talking about how, actually when we're talking about learning, what we're really inviting is a kind of discomfort, right? And so what I do is I show this to my students like day one, and I say, look, okay, there's not judgment here. This is just descriptive, right? And I can use it for myself. I can also imagine it for another person. We all need our comfort zone, and the comfort zone is not a place of learning or growing. So for us to invite learning, growth, we have to go into this stretch zone, right? We use it colloquially, we talk about stretching, but we really do have to be willing to stretch out of that place of comfort. And yet, stretch can very easily and sometimes very quickly turn into panic, right? Or, maybe it's not panic, maybe it's just a state of overwhelm or reactivity, right? The panic zone is the sort of fight, flight mode zone. So basically, this is a tool that we can use. I'm going to take maybe an extra minute here, but basically this is a tool that we can use, and ultimately the purpose of teaching this tool is so that I can notice whether it's from comfort or stretch, when I'm starting to move into that panicky place, and I'm trying to not do that right this minute. And what do I need to do to bring myself back into that learning mode, right? Because in the panic zone, we're not learning either. We're not able to listen. If I'm in front of a judge and that moment where like my brain just sort of shuts off, if I just say, Your Honor, may I have a minute, right? Or I just bring some breath back in so that literally it can get into my brain. I knew the answer. I was prepared, right? So this is for me a really important, whether you use this tool or not, but thinking about what can we do to create the kinds of spaces and the opportunities for ourselves and our students to learn in this more kind of aware, embodied way. And I think that's ultimately what's going to bring us back, back into this sense of our bodies and into this idea of human-centricness. And I just love this image, but like I think the sort of irony or the paradox of these people that are in this non-gravitational sort of space, sort of like grasping onto each other and grounding themselves in the kind of collective, beautiful sort of relationship they created together is a lovely, metaphor for, I think, where we need to go. All right, thank you so much.
It is wonderful to be here with so many people that I've known for so long that have meant so much to my life and my career, but also love being in a room with law students. That's why I still do what I do. It says Professor Emeritus, which is true. That means I retired a year ago. But the one thing I did not retire from was teaching. All the rest of it I can let go. But I thoroughly enjoy law students. In fact, I'm going to talk about teaching today. I'm going to do as some others have done today and go back a little bit over my own personal history. My long and winding road, I have been attempting to teach professional identity myself for back into the 90s. Now, I need to let you know, I didn't use the phrase professional identity. I wasn't aware of that. That wasn't the way we characterized what I was doing in class at the time. But even back in the 90s, I was teaching a couple of different classes in which the idea was students should come up with their own personal mission statement, maybe a credo you could call it, so that they could answer the fundamental questions, who am I and what am I doing here? I did that first in my externship class. I thought that students are learning how to be lawyers out there in the real world. They ought to be thinking about what this means for who they are, where they're going. And then started teaching a seminar. I've taught in clinics for most of the last 4 decades, externship and clinics. But in addition, I have, for 30 years, most of those years, taught both professional responsibility and criminal law. For much of the last decade, I've taught first-year civil procedure, and I've also taught seminars that were focused very expressly on professional identity. What I want to do today is talk about the lessons I've learned, and I'm going to talk, and there are 10, you notice. I just came up with that number. Good enough for Moses. David Letterman, I guess it'll work here. These, though, are lessons specifically about teaching. And so in one sense, they're directed at the teachers in the room. And I hope maybe beyond the room eventually. And I want to see if teachers in the room, these resonate with you. I think you'll see there's some pretty common themes in what I'm going to say from what you've heard already from really all of the speakers. But I hope also you students in the room will be thinking about these lessons for teachers and see if they resonate with you. Is this something you've experienced, something you'd like to experience in a classroom, something you think, don't do that in my class. But I want everybody to understand, I'm not here to talk about what is professional identity formation. I'm not even here to talk about issues about what should be in the law school curriculum, how should we structure the institution in order to, those are wonderful questions, and I like those discussions, but I'm focusing very specifically on issues of pedagogy. That is, if what you want to do is work toward professional identity. Now, let me tell you right off the bat, you notice I used a verb right up here, lessons learned about teaching professional identity. And then I think I did it again in this slide. I've been trying to teach professional identity. Well, as Ben let us know earlier, you don't teach professional identity. If it's a matter of instruction, you failed at the outset. Teach is the wrong verb. Formation is what we typically use, and that actually comes from some spiritual traditions, and there's a good reason for that. This verb doesn't work most of the time, but I like it. Cultivate. I think now that my job is to cultivate each student's professional identity. It's up to the student to grow, but I can even plant the seeds and I can water and give them the right environment. But at that point, I've done all I can do. So anyway, these are lessons I've learned. And the first one is, if you want to work toward professional identity in any particular course, and again, I'm not talking about curriculum-wide. I'm talking about if you are teaching a course in a law school, and what you want to do is work toward the student's professional identity, cultivate their identity, you've got to be quite explicit that's one of the things you're trying to do in the class, explicit to the students. I put this up here because students come into a classroom assuming that most of what's going to go on is I'm going to learn things I need to know. And then I'm going to have an exam at the end where I tell the student tell the teacher what I know. In some classes, I'm also going to learn how to do certain things. And that happens in pretty much every class. But if what you want to do is help students form their professional identity, you need to let them know right at the outset of the course that one of your goals is about who they are and who they are becoming. And when I say an educational goal, I don't mean just one of those bullet points on the syllabus that they make you do now on a syllabus in law school. I mean being very clear and explicit to the students. That is one of the most important things you're trying to accomplish together with them in the class. I said, if you're doing that in a class, here's my pitch to you. It needs to happen in every single class in law school. I said, I'm not going to talk about curriculum a little bit. I think it's fantastic that we now have, over 100 first-year courses focused on professional identity. I can't even imagine. I wouldn't have been able to imagine that 20 years ago. That's great. But identity is being formed in every course. I mean, Jerry Organ's written about the hidden curriculum. Law school is having a profound impact on you, as Megan told us about. All kinds of experiences are. What's happening in law school is shaping, forming your identity. And that's true in every course and extracurricular and outside the building stuff. My pitch to teachers is whatever course you're teaching, you need to make identity a goal in that course. Be explicit, be intentional about it. Now, it's not the only goal in every course. As I say, I teach civil procedure and criminal law, professional responsibility. There's a lot of knowledge, there are a lot of skills that I'm trying to get across to the students. There are other courses where, that's the main goal. But I guess what I want you to recognize is, don't sleep on the fact that even in a large doctrinal course, there is a lot that can be done in a positive way to help the students form their professional identity. Lesson number 2. It's not just that you say, we're going to help you develop your professional identity as the ABA says we should do. I think you got to be pretty explicit, pretty intentional about what your goal is. I'm assuming that students are in law school in order to become lawyers. I'm well aware that plenty of people take a JD and then go in different directions. But I'm teaching to a class that will all, when they graduate, almost all take a bar exam and get a law license. And so I am focused when I teach that I have in mind a certain kind of lawyer that you want to be. And it's a lawyer who is very good at being a lawyer. That's one reason law school is hard. It's demanding because the practice of law is demanding. We want students to really, I love the language from Neil and the Holloran Center about, and I can't quote it exactly, about professional value is the continuing commitment to excellence throughout your career. That's I want my students to know that's what I want for them. But it's absolutely essential that the students learn to practice with ethics and integrity. The third thing is, early on, I want my students to know I want them to live a fulfilled life. You saw a reference earlier to this book that came out almost 30 years ago by our good friend, the late Steve Kiva. The subtitle of the book, Finding Joy and Satisfaction in the Legal Life. I want to convey to my students right off the bat, this is a good life. You can live as a lawyer. This is what we want for you. You've already seen this group. They're still happy. But they're obviously lawyers, see the way they're dressed, but they're good at being a lawyer. They are ethical, and they're thriving in that life. Third lesson. If what you want to do is help students form their professional identity, I think we need to take the standard seriously or more particularly the interpretation 3035 of the standard, which says professional identity development is about what it means to be a lawyer, the special obligations lawyers owe to their clients and to society, and it needs to focus on the values, the guiding principles, the well-being practices of a lawyer. Now, Lou was right. As a society, we don't have a consensus on certain values. I mean, I've been around a long time. We are as polarized as a nation today as I ever remember it. But I think it's fair to say we in the legal profession have a set of core values. If you keep it pretty straightforward. Somebody mentioned the ABA preamble. The very first sentence of the model rules of professional conduct says a lawyer uses identity language. It tells you what a lawyer is. A lawyer is first a representative of clients. The vast majority of lawyers represent clients. It may be individuals, it may be corporations, they may work in-house so they have just one client, they may work for the government. But whatever you do, I think we can agree as lawyers, if you're going to represent clients, you need to do it well, competently and diligently. And you have certain fiduciary obligations. You have to serve. You have to subordinate your self-interest occasionally to your clients. But you're not just a representative of clients. Just as important is the second part. You're an officer of the legal system. And that means there are you don't just do whatever the client wants you to do, regardless. You have a commitment to truth. You have a commitment to respect and treat everybody fairly. And then this part has come into play much more recently. It's always been in the preamble, but it's something we've had to focus on more. Lawyers are public citizens with special responsibility for the quality of justice. We have a commitment for equal justice for all. We need to do all we can to overcome injustice that's still systemic within our legal system. And especially nowadays, we need to think a lot more and work more about our commitment to the rule of law. So anyway, I know there might be some dispute about values. I hope if you want to be a lawyer, you're committed to this. And if you're not, I don't want you to be a lawyer. There. Along with that, I said I need you to be positive. You need students. Practicing law can be good for your clients. It can be good for society and good for you personally. We'll get to in just a little bit. Sometimes you have to give them a reminder. And if you haven't read Just Mercy, you need to. At our school at Mercer, all of our first years read it. I was delighted when I started teaching at Georgia State. And this past year, all the first year students read Just Mercy before they started law school, having a role model like Brian Stevenson, who shows what can be done. Now, here's what you have to worry about. If you read Just Mercy, or if you look at the real world much at all, you realize there's a lot about our legal system that isn't working right, that isn't just, that isn't fair. If you're in a law school class, your professor may point out to you, or you may see it yourself, that's a lousy opinion. That's an unjust result in that case. It's easy to become cynical. It's important to be critical of our legal system and decision makers in the legal system. But if you dismiss the whole enterprise of the whole legal system, I think we've lost everything. Okay, lesson 4. Now, we've talked about this repeatedly. The point is, if you want students to internalize the lawyer's identity, they've got to embody that role. And I think real world experiential education, working while they're in law school, is all absolutely essential. One more point about curriculum. We need a lot more experiential education, clinics and externships in the curriculum, a lot more. But in addition, even in the large doctrinal courses, criminal law, civil procedure, the more we can have students approach the problems, approach the cases in the book in the role of a lawyer, the better off we are. In criminal law, I'll have this group of students make the best argument for the state in this case, make the best argument for the defendant. In civil procedure, I have them draft pleadings and discovery documents just to start acting as a lawyer. This one is essential. In the classroom, you really need to build the right kind of community of trust. And these are ways to do it. Maybe most important as the teacher, just get to know who they are. In a seminar or a clinic or externship, no problem. You learn them very quickly and you work closely together. If I've got 70 or 80 students in civil procedure, it takes a lot of work to learn who they are, to call them by name when I see them, to learn a little bit about them. My pitch is that work pays off. One way I do it, and I've been doing it for a long time now, I learned it at a conference somewhere a long time ago, have every student do an introductory video of themselves and I give them a whole list of questions they have to talk about themselves, some of them fairly personal. And I go back and I look at them repeatedly all along in the semester. And that helps me. I've taught so many thousands of students now over a long time. I still hesitate sometimes to call somebody by name. I think I know who they are, but I do feel like I know who they are. That makes relationships. How many times do we have to talk about that? I think it's important to let them get to know you. You're not just the person behind the podium. You're a real person. You're a lawyer. You're a teacher. I share a good bit about myself in front of more than my wife would like me to, and my children and my grandchildren. I play music before every class just as we're gathering, but it's always music I like that might have some connection to what's going on in the class. It's usually something from my life. Okay, boomer, you're playing all that old stuff. But if I explain why I am and what the point is, it just gives them an insight into me. And again, you've heard this already, they need to talk to each other. So if you're in a large class in particular, divide them into groups so that they talk with each other about the problem of the day or even on some more identity-focused issues. And some of the really old people will know who that is, but Professor Kingsfield of the paper chase, you do need to set clear standards about what's expected in the class because the practice of law has some pretty clear and demanding standards. And at least as importantly, you got to meet those yourself. And that's because you as the teacher might very well be the first lawyer role model these students have ever been around, and they get to know you pretty well. And how you behave imprints on them, this is what lawyers are. So you need to be self-conscious of that. But it's never appropriate to demean a student. Susan is right. Kindness will take you so far. I think all professors need to be Neil Hamilton professors, and that's my pitch. My sixth rule is, as much as I keep emphasizing the positive, you can live a great life as a lawyer. You can make a difference for clients in the world. You can be fulfilled. There's plenty of negative in the world. And the truth is, we've heard from so many people, and it's still true, a lot of law students are experiencing a lot of stress. They're afraid. There are all kinds of difficult, serious personal situations going on that we often don't know about as teachers, but we need to be aware of it. And of course, if you look at the real world now, it's never been worse in some ways for the rule of law and the legal system. But that's all the more reason that we have to buckle down there. One lesson on this is if students know that they're not the only ones feeling that. So I have students reflect a lot and write things. I don't make them reveal themselves unless they really want to. But I share often anonymously what other students are saying, and that's helpful for a lot of students. Resilience and grit are just two things that are absolutely essential because the practice of law is difficult. Life is difficult sometimes. Things don't always go your way, and you got to learn how to work through that. The last four things I'm going to do in the last minute are talk about two attributes, two qualities that we want all lawyers to have, and then two habits to get to that. I don't need to spend much time on it because people have talked about it already. There's Brene Brown, Susan, about authenticity. The problem here is many students think if I'm going to be a good lawyer, I can't be who I am. I got to take on this other role. That is dangerous and destructive. you've got to be able to practice law consistently with your own values is very unhealthy. If you do live authentically, then you can be a better lawyer, but a better person. The other attribute that's so important, and again, we've heard this several times, a focus on purpose. And we've talked about how so many law students sort of lose that purpose as they get into law school. They get pushed in other directions. Remind them of the purpose that brought them to law school and encourage them to be intentional. Maybe they ought to find a book about a career. Somebody ought to write it, call it roadmap, maybe, something like that. Reflection is one of the first of the two habits. There's so many different ways to do it. My favorite is walking in nature, but there's so many different ways to do it. There are many reasons to reflect. Professionals all need to reflect in order to become better at the task of the professional. The reflective practitioner, Donald Schoen, from a long time ago, you become better at your professional task when you reflect on it. What did you do well, not so well, and do better? But I'm talking mainly about reflection to aid in authenticity. Reflect on what your core values are, what your character strengths are. This I'll talk about if somebody wants to talk about later, but there are lots of tools on the internet to help you focus on what your own character strengths are. My last lesson, I'm not saying anything new up here. Relationships. They are so essential, especially for lawyers. You know, the practice of law is primarily about human beings and how they get along and then don't get along with each other, and we're there in the middle of that. So having good relationship skills, but it includes mentoring. And you have to be intentional about it. That was Judge Phyllis Kravich. You need to Google her. I was blessed to clerk for her my first year out of law school. She was the third woman in United States history to serve on the United States Court of Appeals. I'm old, as you would have thought. That's a Professor Tom Schaefer, who was at Notre Dame. I sent him an article. It's kind of like Daisy and Judah's story. I just thought, this guy's great. He's never heard of me. And he responded so beautifully and gave me great feedback and helped me along the way. You got to get out of your comfort zone sometimes and do that. I've represented several people in death penalty cases. That's the best death penalty lawyer I've ever known, Dick Burr. I was representing somebody who was the first person in the country sentenced to death under the Federal Death Penalty Act in 1994. Dick was representing the second. His client was Timothy McVeigh, which you may have heard of. He gave me hundreds of hours and help along the way. That's a great little book that makes the point you've heard that mentors are often people that see things in you don't see for yourself. And it can be like a student Neil talked about last night that told him early on he ought to be teaching ethics. He didn't know that about himself. A student picked up on it. Close. I am closing. The word joy appears here. Vocation is such an important word. It's not just finding joy in life. It's meeting the world's need. But if you don't have joy in doing it, you're not going to meet the need very well. But if you have joy and you're not meeting the world's needs, you're not living a good life. Speaking of living a good life, this is a lawyer Daisy and I knew many years ago in Texas who inspired me along the way. I'll just let you read that quote. He is right about this, and I want students to know this as well. Thanks, everybody.
Okay, so we have about 10 minutes for questions. Does someone want to start? Any questions?
Question for Megan. That was great. I love this information, but I was curious about whether one of your questions and whether the students at your school would take a course that's focused on professional identity formation, and if that really did have an effect.
Right. They take something. It has elements of professional identification. It's called expert learning. It's also a lot about script like building skills. So we have a tremendous amount of first generation students, and we developed that based on their feedback needing that. I didn't ask about that class specifically because they would
I was hoping that it didn't mean that you had a robust standalone course.
We have a pivot course and nobody thought it was impactful. We don't. And it's a goal of mine, but also like it's have to be really careful because the students were so adamant about wanting that level of support in that course. It's hard to, continue later.
Right, I understand.
Yeah, good question. No, I would hope that the fifth course would be impactful to schools where there's a fifth course.
We don't know. Thank you.
Yeah.
Susan, you, I love your graphic of the comfort zone, the stretch zone, that's,
Which I did not create, by the way.
Yeah, there's when I was, I take a group of students to Merida, Mexico, and there is a big big board advertising the local nursing school, and it says in Spanish, "Success is not found in the comfort zone," and so I just love that. How do you, like, as a practical matter, how do you help students recognize which zone they're in and move from the panic zone or the comfort zone into the stretch zone?
It's such a great question. I mean, honestly, I would say about myself, it's a lifelong practice, right? Like because one thing to recognize is we can move these zones in seconds, right? Like I'm sitting here very comfortably and then I don't see my phone and suddenly I'm in my panic zone, right? Like it doesn't necessarily take a lot. Of course, it could also mean that like I'm sitting here and something activates some trauma that's in my history. So, I mean, these phenomena are just like how our brains and, our bodies function in the world and in space. And so it's a tool, and I do have activities that I do with students. One of them is sort of playing with, like, what are our go-to reactions when we're in our panic zone? And then I get them in small groups and they kind of pick one, right? So it's like attack other, attack self, withdraw and avoid. And we work through different scenarios and then I let them choose one. And so then, they kind of crowdsource, like in their small groups. What are some of the strategies when I'm in this mode in my panic zone? What are some of the strategies that I can use? And a lot of it, really comes back to mindfulness practices, right? Like slowing down, taking a breath, taking a moment. Sometimes I do have to like withdraw momentarily from the situation. And, but I think the bigger picture is that these are lifelong practices. And I think they come up in every situation and they come up in our professional lives. And they impact how we are with each other and with clients and judges, et cetera, et cetera. So like, I feel like these tools and practices are really core to, and I had the opportunity because I did teach clinic and I taught, but I kind of feel like there could be opportunities to introduce this, when we're laying the foundations for how we're going to do the work together in any class, we could introduce some of this into the conversation because it comes up in classroom discussion, right? One student says something, somebody else reacts to it. And, recognizing that if these zones are happening for me, they're happening for somebody else too, right? So it can also be a tool for empathy.
And I think it relates very much to Ben's previous presentation about pushing them out of their comfort zone and, Neil's discussion of AI, I'm real concerned that we're letting ourselves be in the comfort zone all the time intellectually and so what are the techniques to push out of the comfort zone into the struggle zone? I think it's going to be a real interesting question for us going forward. So thank you for that. That was really great.
Let me add here a confession, really. I pretty glibly said one of my lessons was it's important to be demanding without being demeaning. That's a lot easier said than done because we as teachers don't know what's going on in your lives. And I might think I've done something that was just pushing somebody a little bit more, and based on who knows what, or the way I ask the question, it could be traumatic for a student. I've had to learn through hard experience over the years. A student I thought was just blowing me off. His mother died 2 days ago and I didn't even know it. And so the more we are open to who our students are, the better off we are. And I apologize for being glib. Yeah, I think I'm right. You need to demand, and you need to never be demeaning. but where that line is not so easy. I love the image, Susan, of the stretch zone. I'm going to remember that.
Yeah. Other questions?
There, I'm on the list. Yes, thank you. Just to press this a little bit more, I'm sitting here struggling with this. Not in my panic zone, but maybe in stretch zone. I think in clinic and maybe in externships, it's easier to do. But in a more traditional doctrinal classroom, I'd love Tim and maybe Ben, you could report more on this, and Susan and others, how to do that effectively. Ben and I were talking a little about role plays in class, and role play in a class, our human nature, I think, is to land in the common stop, right? Not to really push each other in a role play to play it safe. So I'm just curious if people a little bit more critical for professional formation. I mean, we hear so much about you learn through struggle, you learn through failure, but most people don't like struggle and most people don't like failure. So how do we, particularly in a doctrinal classroom setting, more traditional classroom setting, how can we push students into stretch zone? I'm not talking so much about the doctrinal knowledge. I'm okay with that, right? How to push them in their mental understanding. In a professional formation setting, in a doctrinal classroom, how can we push them into the stretch zone? I'd love for people to.
And I don't want to eat up too much on that. One immediate thought is, I really do believe that it doesn't, regardless of the class, that I, as the professor, I need to take time. Like this container that we learn in, we have to nurture it. We have to feed it. We can't just, often it's like, we'll spend like a few minutes the first class and be like, okay, here's the syllabus, and, but I do spend a significant amount of time thinking about like, this is the learning environment, right? The learning community. And what do we do up front and along the way to build and feed and nurture a learning community where students will feel like, again, it's not a safe space, right? Like, I'm not trying to suggest, I don't think any environment today is actually a safe space. I think what we're wanting to do is create and nurture a space where students can feel safer being brave, right? Taking risks, being more vulnerable. And we have a big responsibility there because students are coming in not on an equal playing field, and they're coming in with a lot of armor, and we need to respect the armor, I think. And so, but then like, how do we nurture an atmosphere where students will take more risks and be willing to be open to critique and that sort of thing. But I feel like there's a big responsibility on the professor. And we often think of it as taking away from content, right? Or, there's so much that we have to cover. But to me, it's really worth the investment. And I think the meaning, we want meaningful learning to be happening. It's not about downloading information.
Yeah.
Just as a follow-up to Nat's question, right? And I think the Next Gen Bar encourages professors to think more about this, right? The traditional bar exam asks questions of students in the role of judge, right? The multiple choice questions ask you to decide. Lawyers don't decide. Lawyers evaluate and then seek information and advise and counsel. So to me, part of this, it's not necessarily a deep engagement and role, but it's just make sure you're asking questions about the information that puts them in the role of lawyer, right? What do you know? What don't you know? Where would you get the information you would know? How would you advise the client? Not necessarily what would you argue to a judge, right? But how would you advise a client? That is shaping you as a lawyer rather than a decision maker. So I think there are simple ways you can do some of this that I try to do, and you can ask any of the students I've had whether I was successful, but that's what I've tried.
Very quickly. But
it's up to Rebecca.
Well, briefly, right? Most of us have, that's part of the way we evaluate students. And I find the students are very, very mindful of how they present. It's not necessarily a safe environment because they're watching each other and they're talking after that. She said this or she said this. So I totally agree to what you're saying, but really hard when someone in the culture is kind of walking here for that.
Yeah. Thank you all. We're out of time for questions.
Good afternoon, everyone. Thank you again so much for being here. My name is Grace Hinton, and I'm a 2L here at St. Thomas. And it's my honor to introduce to you our third panel. So this one is Alternative Pathways and Professional Formation Across a Career. And we have Janice Trapp, Leanne Booth, and Barbara Slesner-Fine speaking on this topic. Our first speaker beat me up here. So we have Janice Trapp, the Director of Professional Identity Formation and Associate Professor of Law, Legal Practice at the University of Richmond School of Law. Thank you for being here.
Thanks. You might have wanted to have held your applause, because actually I'm no longer an associate professor of law legal practice. I'm a professor. Very exciting stuff. Okay, I'm going to start my timer, so we're going to have everything going here. I was going to do a moment of mindfulness, but Jerry stole my thunder, but that was lovely. Thank you, Jerry. I appreciate it. Speaking of thank yous, I do just want to take a moment to thank Quinn and the rest of the members of the University of St. Thomas Law School Law Journal, and to everybody at the Holloran Center, most especially Felicia, for making this event possible for all of us. So the gist of my presentation today is to argue that legal licensure is not neutral. It allocates power. It determines who becomes a lawyer and how. It shapes how lawyers imagine what the law is for, whom it is meant to serve, and where lawyers' professional responsibilities begin and end. And in my view, it reproduces existing hierarchies and power structures that ultimately harm lawyers, would-be lawyers, and the public in whose interest we ostensibly serve. So in this presentation and eventually in the paper, I am trying to do a couple of things. First, to examine legal licensure through a law and political economy lens, understanding licensure not just as regulation, but as a system that distributes power and opportunity. And second, to explore how that system shapes the professional identity of law students and lawyers. In other words, how law students and lawyers come to understand what law is for, whom it serves, and what roles are possible. So when we're thinking about the discourse around law and licensure, we note that the conversations on this topic tend to center around consumer protection and competence on one hand, and access to justice on the other. And when I'm talking about the discourse around legal licensure, what I'm really talking about are things like diploma privilege, supervised practice, rethinking Rule 5.4, and non-lawyer investment and ownership in law firms. And I would say most relevant for this presentation, rethinking limited legal services delivery by non-lawyers. So that's really where my focus lies. Okay. These frameworks do many things very well. They ask very important questions. So for example, the consumer protection competency frame focuses on something incredibly important, protecting our clients from incompetent or unscrupulous providers. This takes harm very seriously. It emphasizes universal standards and accountability to which we all should hold ourselves. Good things. The Access to Justice framework focuses on expanding access to legal services, pretty obvious. And of course here, the strength of this framework is that it centers unmet needs, pushes for reform, and challenges exclusivity that limits access. But I would note that these important questions tend to be asked within the confines of the pre-existing structure, rather than interrogating how the structure itself allocates power. So for example, in the consumer protection framework, we ask, how do we ensure quality and prevent harm? Important question, but this perhaps leaves on the table other important and structural questions. For example, who defined competence in the first place, and is it acceptable? Do we like this version of competence? Whose knowledge is recognized and valued? And how these understandings determine who can enter, claim membership in, and benefit from the legal profession. Similarly, the Access to Justice framework is really concerned with how are we going to expand legal services, an important question, and we may be giving short shrift to other important structural questions underneath that could be interrogated. So for example, we're not necessarily asking how certain legal structures themselves define what counts as legal need, shape the form that legal help takes, and reinforce certain professional hierarchies in legal practice. So I think that these conceptual gaps encourage us to widen the aperture through which we view legal licensure and licensure reform. And this is where I offer law and political economy as a framework to help fill those gaps and to serve as a complementary lens to analyze questions related to licensure reform. And I'll explain in a moment why I think this is a useful framework, but I first just need to explain briefly what law and political economy is, because it's not something that's on the tip of everybody's tongue. I will note to the LPE experts in the room, this is a very incomplete primer, so I make my apologies now. You can come scold me or castigate me later. Feel free. Okay, so again, incomplete primer. Whereas traditional legal frameworks are often going to treat law as a neutral referee, so something that stands outside of markets and simply ensures that they function properly, LPE challenges that narrative. So the LPE framework offers that law isn't external to any markets, that in fact it's constitutive of them. LPE posits that markets are not neutral or natural, they are legally constructed. And what we often think of as this neutral or natural marketplace is actually built through very purposeful legal rules about property, contract, labor, corporate organization, and others. So these rules don't just facilitate exchange, they don't just ensure efficiency, but they actually allocate power and resources. And as a result, they shape who benefits from economic activity and who doesn't. So instead of asking only whether a system is efficient or whether it achieves stated regulatory goals, LPE is going to ask, how is law structuring power? Who benefits from those arrangements and who doesn't? And what role does law continue to play in shaping market outcomes? So using that lens, what comes into view is that markets, including the legal services marketplace, aren't neutral or natural. They are the product of legal choices about power, distribution, and priorities. And we are then invited to consider that what looks like a neutral outcome often reflects deeply and purposely structured sets of legal decisions. As applied to legal licensure, then, a law and political economy framework uniquely foregrounds conditions that might otherwise remain in the background by asking, how is power and opportunity distributed by virtue of legal licensure? Who is authorized to provide legal help and on what terms? How do these structures shape the profession itself? And when I'm thinking about shaping the profession itself, I'm also critically thinking about how does the near exclusive distribution of power to lawyers to practice law shape our professional identities? What happens to us as a result of that near monopoly? So by centering these questions, the law and political economy framework illuminates how licensure distributes power and opportunity. It illuminates licensure as a governance model. It's a market-making and market-constraining force. It doesn't just regulate competence, doesn't just regulate entry, it structures the legal services market itself. For example, licensure solely determines the supply side of the legal services marketplace, right? LPE illuminates licensure as distributive and exclusive, having both effects. So by virtue of licensure, we decide who gets to become a lawyer, we decide who gets excluded, and we also need to ask ourselves who is going to capture the economic and social capital attached to the role of lawyer. And then finally, I would offer that this framework illuminates licensure as constitutive of professional identity. And I often wonder if maybe it's in some ways determinative of professional identity, but we'll get there. So LPE asks how the profession's structure as constructed by licensure shapes the profession, not only in terms of governance, but by shaping how lawyers and would-be lawyers understand their role, responsibilities, power, and how they ought to wield that power. So let's look at these in turn. So when we think about licensure, again, we're often thinking about it as a gatekeeping mechanism, something that determines who can enter the legal profession. But from the LPE perspective, licensure is doing more than controlling entry. It's structuring opportunity and allocating professional power within the legal field. Licensure is determining who is authorized to provide legal advice, who can represent clients in court, and who can access certain types of work. And because legal work is tied to, for example, income, influence, and authority, licensure becomes a system that distributes not just credentials, but power. To suggest that only attorneys can and should provide legal services concentrates authority in a particular group of people. So if licensure is allocating power, what exactly is it distributing? So legal licensure provides access to multiple forms of capital. It provides access to economic capital through income, particularly in certain sectors of the profession. Licensed attorneys can access high-paying jobs and roles, especially in corporate law or large firms that are simply unavailable to non-lawyers. It provides access to social capital through professional networks, institutional affiliations, and status. Lawyers gain entry into professional networks, firms, bar associations, alumni pipelines that shape career mobility and influence. And finally, it provides access to political power because lawyers are, in fact, disproportionately represented in legislatures, courts, and leadership roles, giving them outsized influence over how law is made and interpreted. So if these are the benefits that are distributed, the next question is who is left out? So who's excluded? So exclusion via licensure operates in several ways. So licensure limits access through, first, barriers to entry to the profession, such as the cost of legal education, the structure and the cost of the bar exam, not to mention the 3 months of unpaid study or 2 months of unpaid study one dedicates to that exam, and character and fitness requirements. Second, licensure limits access through narrow pathways into the profession, which tend to privilege certain educational backgrounds, career trajectories, and forms of experience. Within the profession, we're already very familiar with this sort of thing. We know about elite hiring pipelines, such as those in leading large law firms, that tend to draw from a very small set of schools, reinforcing who gets access to certain types of power and authority. And third, licensure limits access through the reinforcement of hierarchy, both within the profession and between lawyers and non-lawyers. So unauthorized practice of law creates a sharp boundary between lawyers and non-lawyers, even when non-lawyers may have deep expertise in particular legal problems. So before we shift to how licensure impacts formation, I did just want to briefly pause here and just kind of answer the okay, so what question, right? What is the impact of thinking about legal licensure using this particular framework? What have we done here that is different than what we might have done using another framework? So I would just offer that there's a few important effects of viewing legal licensure using the LPE framework. So number one, it's going to shift the object of our critique. Without LPE, conversations about licensure are going to focus again a lot on standards and competence and access. But with LPE, our focus is going to widen and ask the question, what kind of profession is the system designed to produce and who benefits from that design? So we are then challenged to see licensure as more than a quality control mechanism and start treating it as a policy choice about how to structure the legal market and the profession itself. Secondly, it reframes reform from exception to design. So we notice that there are many current admirable reforms that are happening when it comes to legal licensure and the provision of services, but a lot of these reforms, including pilot programs related to limited licensure, regulatory sandboxes, these operate like narrow carve-outs or fixes at the margins, whereas LPE is going to push a different approach by insisting that the system is producing exclusion and hierarchy, and we can't just add exceptions to that existing system. We need to consider the baseline design. We have to ask whether the work that licensure is doing, the distributional work that licensure is doing, is something that we are willing to defend as members of the legal profession. Thirdly, LPE makes distribution visible and contestable. So again, LPE is foregrounding a question that often stays implicit, which is who gains and who is left out under current licensing rules. This includes aspiring lawyers, the public and prospective clients, the profession itself. And the implication here is that reform conversations must include trade-offs, not, again, just technical improvements. Protecting the public can no longer be invoked without asking which public and at whose expense. And conversations about consumer protection and competence must include questions about who captures the benefits of this exclusivity. But finally, this is what I really want to get into. So finally, there we go. So finally, we want to talk about licensure as formation. And I think that the Law and Political Economy framework actually helps link licensure to PIF, to professional identity formation. So thus far, I'm using and I'm talking about the LPE framework to describe licensure as a system that distributes power and opportunity. But what I really want to offer is that licensure does something even more important than governance, that it in fact helps determine, and again, maybe even predetermine, who lawyers think they are, can be, and should be, and whom and what they think law is for. So when we think about the pathways into the profession, the boundaries that licensure itself draws, and the roles it recognizes, all of these things send signals about what law is for, whom it serves, and what kinds of practices are valued. And we know that this is happening, right? We know this is happening within law schools. We know this is happening within the profession. My curiosity is about the licensing regime that exists adjacent to, but nevertheless outside of, legal, educational, and professional institutions per se. And my concern with this licensing regime, as it predominantly exists, is that it today is recreating conditions that make it more likely that law students and lawyers will cultivate professional identities grounded in exclusivity, authority, and control over legal knowledge, not necessarily in service, self-sacrifice, or public-spiritedness. So, for example, when entry to the profession requires years of expensive education, a high-stakes exam, would-be lawyers may internalize that expertise is scarce, hard-won, and therefore exclusive. Over time, this comes to shape how lawyers understand what lawyering is for, what it's primarily about, whether we work in service of delivering technical legal solutions to sophisticated clients, or whether our priorities are addressing human and community needs through law. Licensure shapes what counts as legitimate legal practice, what roles are formally recognized, which are marginalized, and which aren't imagined. So we see this in the unauthorized practice of law rules, which draw that boundary around who can give legal advice. The boundary doesn't just regulate conduct, it signals that legal knowledge is uniquely held and must be delivered by licensed lawyers, even in spaces where trained non-lawyers may be deeply knowledgeable, trusted, and because of where they are situated, qualified to provide legal advice. So when only licensed lawyers can give legal advice, it reinforces a professional identity centered around the idea that legal knowledge is owned rather than shared. And again, relatedly, licensure confers not just professional power, but social authority. Lawyers being positioned as the only legitimate interpreters of law reinforces a professional identity that comes to see hierarchy and exclusivity as naturally and appropriately occurring phenomena in our profession. So I offer that if we want different professional identities, those that are collaborative, service-oriented, community responsive, then we have to be willing to ask whether the structure as a whole, to include licensure, supports or undermines them. I would offer that right now, in the absence of this kind of critical conversation, we are stuck in a status quo preserving cycle without regard for whether that status quo is operating in a way that truly serves lawyers and the public. And there are actual arrows between those things. But what this is meant to signify is that the effects of licensure are not operating in isolation, that they're reinforcing one another, that licensure structures who enters and what is valued in the profession. This is going to shape our professional identity. Our professional identity in turn is going to influence how legal services are delivered, and those practices in return reinforce the very structures that produce them, and on we go. So licensure isn't just reflecting the practice or profession as it exists today, but it can also help to reproduce and sustain it, including its hierarchies, assumptions, and limits. And to the extent that lawyers are forming professional identities that are constrained in imagination and limited by licensure, the consequences are borne most directly by clients and communities, especially those with the least access to legal services. So I'm about to wrap up. So when we ask whether to expand or reimagine pathways to legal licensure, we're not just asking how to regulate entry into the profession, we're also asking something more fundamental. What kind of profession are we building and for who? So in this sense, debates and discourse over legal licensure aren't just about access, consumer protection, competence, or even justice in a narrow sense. They are contests over the values, aspirations, and ethical imagination of the legal profession itself. And I think that that has special implications for those of us in legal education. So many of us are deeply engaged in helping students form a professional identity that is grounded in values like service, empathy, collaboration, public spiritedness, and responsibility to others. The argument that I'm making isn't that this work is futile in the face of an arguably inequitable legal licensing regime. Indeed, it is invaluable. What I do want to offer is that this work isn't occurring in a vacuum. It is occurring within structures that shape and sometimes constrain how students come to understand what it means to be a lawyer. And that creates a tension between what we teach and what the profession as currently constituted tends to reward or permit, a tension that is evidenced by these kinds of questions on screen. So we may invite students to center empathy, collaboration, client agency, service, and responsiveness to community needs, but we recognize that you are also entering a system that through its very licensing regime signals different priorities, including the maintenance of status, hierarchy, and exclusivity in practice. And that tension is going to matter because it affects not just what students hear, but what they ultimately internalize as realistic, valued, and possible. So throughout this presentation, I've suggested that licensure, again, is not simply a mechanism of regulation, but a system that distributes power, shapes opportunity, and in doing so helps form professional identity. And if that's true, the tension that many of us experience isn't incidental, but structural and malleable, which is why I don't think these questions diminish the importance of the work that any one of us is doing. If anything, they underscore its urgency. They suggest that conversations about licensure are not separate from conversations about professional identity, that they are, in fact, part of the same project. So this matters because it means that conversations about licensure reform aren't just about expanding access to legal services. They are about making the work that we do as educators more coherent and credible, and better aligning the values we teach with the structures that students will encounter. Ultimately, we are concerned not only with expanding access to law, but to the range of professional identities that can be sustained within it. And if we want students to become lawyers who embody those types of values, we have to attend not only to what we teach, but to the structures that shape what becomes possible.
Great. It's my honor to welcome our second speaker of this panel, Leanne Pugh, professor of law at Mitchell-Hamlin School of Law, where she teaches, among other subjects, professional identity formation.
Awesome. Thank you. Hi, everybody. Nice to see you. I'm so glad that Janice preceded me and I get to sort of build on that amazing presentation. She did such an awesome job laying the groundwork for why and how we're thinking about alternative pathways of all sorts. And just, I am always very inspired by that conversation. I love when students get to think critically about what does it mean to be a lawyer and what does it mean to let other people do things that are sort of traditionally lawyering work. I think those are really good questions for us. So my name is Leanne Pugh. I am, as was mentioned, on the faculty at Mitchell-Hamlin School of Law, which for folks from out of town is just across the river, about 6 miles away. I am, while at Mitchell-Hamlin, I do a variety of different things. I teach courses in doctrinal areas. I teach our professional identity formation course. I also continue to practice a little bit as a lawyer and do some advising of law firms on leadership and kind of practice management and culture and strategy and things that, you know, are sort of on the other end of the bridge from law school and but are influenced by what we do with lawyers inside the law school. Relative to this discussion, I'm also going to be talking about alternative pathways, but I'm focusing on sort of a niche of what Janice was talking about, alternative pathways in the context of JD licensure, becoming lawyers leaving law school and becoming licensed through other methods besides the bar exam. And for those of you who don't know, those of you who are in Minnesota do know this, Minnesota is one of a very small handful of states that is kind of leading the way in this area. We are exploring different pathways to licensure, 2 specific pathways, a curricular pathway and a supervised practice pathway. I'll talk a little bit about what each of those means and really sort of the connection that I'm making to professional identity formation is similar to what Neil talked about. This is a moment for professional identity formation to be able to provide a structure for how we are evaluating lawyers in licensure through these alternative pathways. There's very much a need to do it, and also we have to figure out how to do it. In 2024, the Minnesota Supreme Court appointed an implementation committee to work on this here in Minnesota. I have the good fortune and great pleasure of being part of that implementation committee, along with a lot of other folks in the state, including representatives from all three of our law schools. And so much of what you'll hear me say is making reference to the work that our committee is doing and how maybe unintentionally, that is inviting us thinking about what professional identity formation tells us, what it means to be a good lawyer. So for those of you who have spent any time thinking about licensure and you sort of get into and read maybe the language, interestingly enough, licensure very much focuses on this idea of competence, and maybe something that was surprising to me and maybe others when I got into reading about the language in Minnesota and in other jurisdictions, it actually uses the phrase minimum competence, which I think is entirely sort of antithetical to what we're trying to do in law school. And I think that this sort of exploration of alternative pathways invites us and maybe mandates us to think about what we're looking for in licensure differently, right? Historically, our licensure has been the bar exam. You sit for the bar exam, it's the multiple choice, it's the essay questions, and we're trying to get out of there with a sort of minimum kind of passing score. And that is what the bar exam has been traditionally based on. Jurisdictions that are exploring alternative pathways to licensure are doing so for a lot of different reasons. Access to justice reasons, some of the things that we know about sort of the inequitable results related to the bar exam. And this work has been going on for a very, very long time. What you'll see me talk about here shortly is some of the recent, what I'll call movement from jurisdictions across the United States. But that movement is not sort of a flash in the pan kind of overnight. People who have been following this or have been in this space have heard conversations about why the bar exam does not prep us for practice, why it does not evaluate the things that are important to law practice, and why maybe alternative pathways would be better. So we've seen a lot of movement post-COVID because COVID brought to the forefront why the bar exam was not helpful in a lot of ways. But a lot of this work has been ongoing. So I'm going to just spend a little bit of time on that. The connection to professional identity, and we've seen a variety of different descriptions about this. Professional identity, we have come to understand, is this idea of a deep sense of self and understanding of the legal profession. So our own values and the values of the profession, which then informs and influences the way in which we relate to our clients, colleagues, and others, how we act in performing on our lawyering work and delivering on the lawyer and legal profession's special responsibility for the quality of justice, which comes from the preamble and leads to a satisfying and meaningful career in the law. So I like to think about this and talk to my students about this as the how and the why of what we do. We can talk a lot about the what we do. We do client counseling, we do negotiation, we do drafting, we do legal research, all of those activities. But our identity informs the way we uniquely show up to do those things and what our purpose is in coming to this work. So as we think about our sort of methods of licensure, our system of licensure, I said before that we very much historically have been based in this idea that what we're looking for is competence, right? We are looking for competence, or if you look at the language of different jurisdictions, maybe we're even looking for just minimum competence. And what I think this sort of entry into thinking about different ways to license attorneys gives us an opportunity to say it's actually not just competence that we need. We need something more to be good lawyers. And we have been recognizing that in the law school environment. We've been recognizing that in the practice environment. But the licensure environment, the bridge from law school to practice, has still for a very long time been focused on this measure of competence because competence has been easier to measure through very objective standards like the bar exam. Enter alternative pathways to licensure and some creative thinking about how we can evaluate whether someone is going to be a good lawyer, whether somebody is going to be what I'm going to refer to as professionally whole or have some sort of sense of professional wholeness. And that doesn't disregard competence, that doesn't disregard knowledge of the law, it doesn't disregard sort of the technical skill. All of that is captured in professional wholeness, but it goes a step further to what we know attorneys need to have when we're sitting there that first day in practice in our law firm, in our public defender's office, in our prosecutor's office. We need to have the knowledge and the skill. We also need to have a sense of who we are and why we're doing this work. We have to have a sense of ethics, and we have to have this sort of integrated ability that pulls all of those things together to bring our unique judgment to that work. So lawyering is not just what we know. It's not just the information that we cram into our head and try to memorize for the bar exam. It goes beyond much more than that. It's why we do, it's how we do the things we do and who we are becoming. Just a nod to, we've talked about a lot of different sort of studies and work that has been done over the years. The Carnegie Report is very much a foundation for this, but also the Foundations for Practice Report, and Zach is most familiar with this, and I'm glad he's in the room with us today, from the Institute for the Advancement of the American Legal System. It is interesting to me that we have this licensing system that is wholly based on competence, based on test taking, based on memorization. And we have all of this information that tells us that is not what we need to do when we get into practice, right? The Carnegie Report started that for us. Studies like Foundations for Practice and the Delta model and others that have come out more recently have reaffirmed that. Foundations for Practice is a study that I rely on heavily with the teaching that I do and in the work that I do with students. But the takeaway, if you're not familiar with it, is this idea that we are a whole lawyer. We are not just sort of the knowledge set that we gain in law school. We are many other things that very much align with the discussion that we have about professional identity formation. And the outcome of the study, in a nutshell, is that practicing lawyers consistently identify a broad set of competencies that go beyond knowledge of torts and knowledge of contracts and whether you know the federal rules of civil procedure. It is a much sort of broader spectrum and deeper spectrum of knowledge and skills and competencies that we need when we get into practice from day one. And so why are we not, as a profession, licensing based on that full set of competencies? So enter alternative pathways in this idea that maybe we can license lawyers and evaluate them in the context of the work that they do, not just what they can cram into their heads and sort of spill out onto a piece of paper or a Scantron in 2 days or however many days it is in your jurisdiction. A number of jurisdictions across the United States are looking at this. There's a few different models that kind of sort of go in a couple different directions. This idea of supervised practice, which we might also know of as like an apprenticeship, something that we do after law school graduation. And other jurisdictions are looking at a model that looks a little bit more, or sometimes referred to as a curricular pathway, something that you do as you are moving through law school. All jurisdictions, I think for the most part, are still requiring law school as sort of a baseline requirement. But both of these options or categories, and they will take different shapes in different jurisdictions, are evaluating new lawyers for licensure in the context of working with real clients and taking on real responsibility, using that reflective judgment that we try to teach them in law school and having them put it to the test in the context of real work, whether that's happening after graduation or while they are still in law school. And maybe most importantly, measuring their work and their ability to practice law over a period of time through the development of a portfolio over a period of time, instead of how did I perform in those 2 days of the bar exam, right? Which I think many of us understand is just not a good way to evaluate. So this just gives you a sense of what the different jurisdictions are that are looking at this. I am most familiar with Minnesota, so I'll tell you a little bit about where Minnesota is at with this, and then make just brief reference to some other jurisdictions. Minnesota has been working on this for quite some time. In 2024, our Supreme Court issued an order establishing an implementation committee to look at 2 things, a curricular pathway and a supervised practice pathway. That 2024 order followed on many years of exploration and study that had been engaged in by our Board of Law Examiners and others, including the 3 law schools in the state. But 2024 was the moment where the court said, we think we want to move forward based on your prior recommendations. And so these are the 2 things that we're looking at. A curricular pathway, which is a pathway through law school for graduates or for people who are going through law school and intending to practice in Minnesota. That has been underway for about the last 2 years. The development of that, the proposal has, and some of you may have seen it and even commented on it, the proposal has been made available by the Board of Law Examiners for public comment, and a proposal that outlines a plan for actually implementing a curricular pathway will go to the Supreme Court at the end of June. What does that mean? It means that there will be a framework for law students as they go through law school about the kinds of things that they need to do during law school to develop that portfolio of work that demonstrates their ability to practice. This looks a little bit different in Minnesota and in other jurisdictions than, for example, Wisconsin's diploma privilege. For folks who are familiar with that, Wisconsin has a diploma privilege where if you graduate from a Wisconsin school, you can be licensed in Wisconsin, and the curricular pathway, you graduate from a Minnesota school to be licensed in Minnesota, but there are more specific requirements that you have to complete as you go through that pathway. Things like developing a written portfolio of work, being observed in settings with clients in a clinical or an externship setting, other kinds of things like that. So that's the curricular pathway. That is in fact, the proposal will go to the court in June of this year. The supervised practice pathway is the second alternative that Minnesota is looking at. It is a postgraduate, so after you graduate from law school, it is the one that is most sort of comparable to an apprenticeship structure. The court's order in 2024 asked Minnesota to explore this and see if it was feasible. And so that is the work that is underway now, and recommendations about the supervised practice pathway will be made next year about this time. So supervised practice pathway will look at some similarities to the curricular pathway, developing a portfolio of work, including writing, including observed opportunities to interact with clients, interview clients, advise clients, and other things. You can see on your right there, other jurisdictions that are exploring this, New Hampshire, Oregon, all sort of different variations of either the supervised postgraduate or the during law school curricular pathway. New Hampshire's program is actually the oldest, the Daniel Webster Scholars Program, and was one of the first programs like this to be introduced. But there's a lot of good work in this area that I think recognizes what we and others as law faculty and faculty who sort of teach in the area of professional identity formation have recognized for a while, that it is not just about knowledge and skill. It is about much more than that. So I won't read through all of these, but this just gives you a sense of the competencies that the Alternative Pathways group is looking at in Minnesota. And I just want to call attention to a couple of different things here. Number 4, the ability to communicate effectively with clients, lawyers, courts, and others. Number 5, the ability to plan work activities, to act diligently and reliably in fulfilling one's obligations to clients, lawyers, courts, and others. And number 6, the ability to pursue self-directed learning, employ self-reflection, and learn from feedback. A couple observations about that: not things that can be tested on a bar exam. And also a lot of words in there, a lot of things in there, a lot of concepts in there that are very much part of the work that we do in professional identity development or professional identity formation. Maybe one of our biggest challenges, actually AI is a second challenge for us, but before I jump there, one of our biggest challenges is to figure out how are we going to evaluate this, because we spend a lot of time in law school thinking about and evaluating these things. How do we do that in practice? And that is the work that all of these jurisdictions are working through now. The giving applicants the opportunity to develop a portfolio of work, figuring out how that work will be observed by practitioners in the moment working with them, whether they're clinical faculty or licensed practitioners, and how that work will ultimately be evaluated by the Board of Law Examiners, are questions that are being answered, and is where a lot of the frameworks that we're developing, that we have developed and relied on in professional identity, can be helpful in the development of alternative pathways as well. I will only just talk briefly about this because there's lots of discussion about AI to come, but this is one of the things we've been wrestling with. In the law school, we wrestle with this. How do we know whether a student is using AI, and what is the knowledge or the experience that we're really hoping for them to have? We are having those same conversations and questions as we are thinking about this supervised or this sort of alternative pathways work. How can we evaluate whether AI has been used, whether the knowledge and the learning and the experience that we want has been obtained? So at the end of it, the core of lawyering are all the things we've been talking about today: judgment, fiduciary responsibility, ethical discretion, a lot of things that are not up here, emotional intelligence, context-sensitive decision-making. We can't really take the work that we do outside of the context that we're in. And so this idea that the core of what we do is much more than just the knowledge on the test is something that this group and others who teach in this area have known for a long time. And now I'm encouraged that the licensing process appears to be catching up with it. So the future of licensing, I think there's a lot of potential. Not every jurisdiction will do this or will be able to do it. It's very resource intensive, but I think there's a space for conversations about what we understand about professional identity, being an integrated lawyer in this space. So I will leave it there.
Happy to welcome our final speaker for this panel, Barbara Lesner-Fines, Dean Emerita and Professor of Law at the University of Missouri, Kansas City School of Law, and Holloran Center Fellow.
Thanks very much. Honored some, will I still be picked up?
Yeah.
I have a teacher voice, so. Okay. Hey, everybody, it's so great to be here, to see so many old friends and make new friends. Our topic, professional identity formation, looking back and looking ahead, and the pathway discussion of this session are where I'm situating my talk. I am just beginning a qualitative study of professional formation over a career. I just got the IRB approval, which was yes, it is a journey, right? Congratulations. That is a journey too. And so I don't have any results to show you. But what I do want to do is kind of show you the design of the study, some of the assumptions that I'm bringing to the study, and get, please, 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 your recommendations. I've already picked up one from Bill here. I shouldn't do these interviews. I should have students do the interviews. But that means going back to the IRB to amend my proposal. So we'll see where I go with that. All right, so that's what I want to do, because I want to talk to attorneys who have been in practice for more than 10 years and ask them to look back, not out of some kind of a nostalgic exercise, although for me at this point in my career, that's kind of fun, right? But to inform how we look ahead, how are we preparing our law students, not just to enter the profession, but for a career in the profession. And I think that is, those are my study objectives, right? Describe how they define what it means to be a lawyer now, how they describe how that's changed or not, or fractured or stabilized or evolved, and then to identify the formative experiences that have led to those changes. I suspect that those of you who've been at a Holloran Center workshop before, where we've always started with Jerry's exercise, when did you first feel like a lawyer? I suspect we're going to hear a lot of the same. I'm going to hear a lot of the same kind of things. That those formative moments, they don't end when you enter the profession. We have formative moments throughout our career. Ben gave us a beautiful example of a formative moment in his teaching career when he was like, oh, I'm in the way. I've got to think about this a whole different way, formation, not instruction, right? So I'm pretty excited about this. One of the things that it strikes me in thinking about this is that a lot of the work we do in professional identity formation presumes that the beginning is the end, right? That professional formation is something that happens during law school, and then when they graduate and become lawyers, they're formed. Bravo. Boy, I wasn't. I don't know about you. And we all know personally, it's not like when we turn 21, we're fully formed adults. And, I'm at a time in my life when I'm looking at, I'm not calling it retirement, I'm calling it job change. But transitions, it's this, I'm in a similar space that my law students are. It's like, what am I going to do when I grow up? And so we know that identity formation, both personal and professional, is lifelong. It's iterative. We keep revisiting some of the same questions over and over our lifetime. And it's responsive to the environment around us and the changes in the environment around us. And so the beginning is not the end. And that is a fundamental assumption that is driving this research. The idea that formation should end when students graduate and enter the profession does them a great disservice, because legal careers, more than ever, are not fixed. Now, I've been at UMKC since I started teaching when I was 12 years old. And that experience of being at an institution, it's now my 40th year there, is not something that many of my students are going to have. They are not going to graduate and go to a law firm and be associate and then be an equity partner and then become, retire out of that. That's not the career trajectory that many of them will have. Hell, it's not the career trajectory that many of my colleagues have had. I'm kind of a dinosaur in this way of being in, one institution so long. I guess I'm just not ambitious enough. But what we're seeing statistically is that this is accelerating. So associate attrition, right? Typically 15 to 25% of annual attrition in large law firms, which is where we often have some of the best data. But there's no reason to believe this is any different in any other sector. A majority of associates leave their firms within the first 3 to 5 years, and that's moving back. They're leaving earlier now than they were in the past. Most go to another law firm, but many go in-house, many go to government practice. Even for those who stay, law firm structures have changed. So it's not like there's just one path to equity partner. These non-equity partnerships are growing. It's a big divide within law firms. And we all know that there is not a single role within the legal profession. Being in-house counsel or a city attorney for a small town or a public defender or a poverty lawyer or a corporate merger and acquisition attorney, these are all different roles. Do they have a core identity? Yes. Yes. Do they have core values that we believe as a profession all of the attorneys in those roles should share? Yes. But they take very, very different shape. And, our legal education has tended to focus on this sector. The idea that our students are going to be going into law firms. Some of us at schools like mine, we also recognize a whole lot of our students are going to be public defenders and prosecutors and going to be in government work. But look at what has happened between 2010 and 2024. The percentage change in the U.S. population of lawyers by type of practice, in-house counsel role, right? So clients are taking that practice in-house. That's a very different role. The studies that have been done about the ethical culture of attorneys in-house counsel practice and their identity. Am I a member of this business? Because a lot of in-house counsel also have, right? They're also, in some kind of corporate officer position. Well, that's kind of competing identities there. And that's going to be shaped. So their formation is not going to be done the day they walk in that door. It's only going to begin. And the work environments are changing. We've already talked about AI, but law firm mergers and dissolutions and technology disruptions. I always tell the students, they like, I need to specialize in this. And they get really, really narrow. And I say, yeah, but be prepared, because with the swipe of the pen, a legislature can eliminate an entire area of practice. So you've got to be flexible. You've got to have a good general background. You've got to, think about how this is going to change. Think about preparing yourself for a career for a lifetime, not for just the bar exam and the first job. Clients change their demands. We see this in that move to in-house counsel. Why is that happening? Because a lot of businesses, they don't want to send it out-house counsel anymore. They want that kind of control. So there's that change. And then even if you're in the old style model, I go to a law firm, I'm an associate, I become an equity partner, over the course of a career, even within one very, very stable career path, your role is going to change. So I was talking to a colleague of mine, a friend who has 3 children. She's at a large law firm. She's very, very successful. She's at the point where she has been awarded an equity partnership. And what's her role now? She's got to develop a book of business. She has to become a marketer. That is the job, number one for her. She hates it. She hates it, hates it, hates it, hates it, hates it. She hates the demands on the time. She hates the role that it puts her in. She's asked the firm to become a non-equity partner so that she can find a role within the firm that makes her more fulfilled, that fits her skill set. So, you're going to move from doer to leader to manager. You're going to have these other roles that, like, how do we teach students in law school to develop a book of business? Policymaker. Being influential. I've been doing CLE season. Our CLE deadline is coming up in June. And so everybody's calling, will you do an ethics CLE? So I'm hot property in Missouri right now. So I was at a Kansas City estate planning symposium, all estate planning, financial advisors and stuff. And there are all these philanthropy organizations, American Red Cross and the local hospital and the Wayside Waste Pep pets and stuff. And I'm walking down, oh, how good to see you, former graduate, director of philanthropy at the pet shelter. Oh, hey, I haven't seen you, director of philanthropy at the hospital. And the story, like there were 5 of my former graduates who weren't practicing law anymore who were directors of philanthropy. Because that's what they liked. They found that in the middle of their career, right? So there's going to be a lot of change over career. And that's all kind of external changes, but we grow. We grow in change in our values. Any of you who have become a parent, it is apparent to you that being a parent is a whole different role change. It takes the way you sleep and eat and think and listen and deal with other people. It's a fundamental change in your personal identity. And there's so many others like that. Well, there are a lot of fundamental changes in how your personal identity is going to interact with your professional identity over your career. And so your motivations and your goals are going to change as well. How do law schools prepare students for this lifetime of formation, for this lifetime of growth and change, much of which will not be within their control? Are we doing professional formation for a lifetime? Well, if we're going to do that, we have to ask what works. What works for a lifetime of professional formation? And that's what I'm hoping my research might give us some insight into. How have people navigated a lifetime of formation? But it seems to me that what I might expect to find is that one of the qualities we really, really, really need to focus on is being flexible and adaptive, being entrepreneurial, right? So we talk about self-directed learning, but this takes it to a whole new level, not just self-directed learning, but entrepreneurial learning, entrepreneurial formation and practice and flexibility and, being able to we talk about the importance of mentorship. I expect I'm going to see a lot of conversation about mentorship. Are we teaching students how to find mentorship over a career? Are we teaching students how to make a pivot? Right? Incidentally, we do. I have students in my office all the time. Oh, I thought I wanted to do this and I was doing this emphasis, but I don't like it. And, frankly, every couple of years I have a student in my office saying, I thought I was going to like law school. I hate it. I'm thinking of dropping out, right? How do we teach people how to do a pivot? Those are kind of having those discussions as though they're off in another corner, as opposed to at the center of formation. And most importantly, what we know for wellness is that we have to, this formation has to be centered in personal anchors, personal values, personal rewards and standards of excellence and goals, and that strength-based work that we heard Susan talk about, that is so important for formation over a lifetime. So let's see what else I might have for you. So, here's where I pretend like I'm a social science researcher. So what am I going to do? Hey, the IRB said I was doing it okay. It's a lot different than the last time I tried to go through IRB approval. I gave up last time. I don't know. Here's the review. So I'm just going to have conversations. I figured between 45 minutes and an hour. I'm just going to solicit a bunch of attorneys and start with people I know. Just random, I'm trying intentionally to make sure that I get a real broad representation of people who have had lots of different kinds of careers, but I am focusing on folks who have been out for 10 years or more. And things I'm already being real cautious about, and I hope you'll give me some advice here. I've thought so much about professional identity formation that I don't want to telegraph, in the questions, I want them to identify their professional identity in their own terms. And I don't even think I want to use the word professional identity. I think I want to be real careful about that and ask, I want to talk about tell me about your career. Tell me about what it means to you to be a lawyer today. How do you conceive your role? And the IRB said it's okay if I go off on tangents. They had some fancy term for it, for like natural evolution of the conversation or something. But we're just going to talk. But I really want to make sure that I get good stories, because I think it's in the stories that I get the authentic data that will help to inform what those key transition points are, that can then help us to think about how we form our students for a lifetime. So the first part of the interview is going to be, tell me about your career, tell me what you think, tell me about your career, tell me what you think it means to be a lawyer today, tell me about your role, values, tell me about how that differs from, if at all, from when you started in the career. And then tell me about what events or experiences led you from here to here. So that's the 4 parts of the interview. And then I'll find some way AI will help me to code the responses. I mean, AI is really good at that, right? Finding patterns. So I'll upload it all, de-identified, of course, yes, IRB, into Claude these days. I like a lot, and see what it comes up with by coding responses. And I'll have my own ideas too. Is that all I have to say?
No, you had one more.
No.
You missed the slide.
Did I have?
That one.
Oh, yeah, here's what I wrote to find. Yeah. This one especially, I think what strategies do lawyers use to adapt their sense of self? There's been some fascinating empirical research about new entrants in the profession whose current job doesn't jive with their personal identity and how they navigate that tension. And so I'm fascinated to learn about that. And then the narratives, like, what stories will be told themselves over your life about what it means to be a lawyer. So that's the plan. Now, I have no time for your questions.
Thank you so much to our panelists. We do have 10 minutes for questions for all 3 panelists. So certainly if you have questions on that topic or any of the topics discussed. Yes.
So I have a question for Janice. Leanne and Janice.
Hi.
And I know we're going to talk about AI, but there's something I'm curious what each of you think about this. I think for a long time the tradition with licensure, but also the role of lawyers in the exclusivity of legal law, and that lawyers are the gatekeepers of that, and that's part of the mirror law. That exclusivity seems to be going away, eroding rapidly. Could be today. And just as an example of what that looks like, right now the courts are absolutely flooded with complaints that are making it past the pleading stage. They're lasting motions to dismiss from people who don't have lawyers. How does that affect the political economy of licensure in the future? And how does that also impact, or maybe even, it seems to me, might think alternative paths?
We're going to need to start by interrogating, benefits from the
Could you speak up?
Oh, I'm so sorry. I don't have the teacher voice, Barbara. I'm so sorry. So did you hear Zach's question?
Yes.
Okay.
That it was about the AI's impact on all this.
Yes, exactly. So I think when it comes to AI and law and political economy, again, the place where we're going to start is always going to be how are legal rules, or how is the law contributing to power differential, or how is the law distributing access or inequality, or things along those lines. And so I think that when it comes to AI, we're going to have to confront that to the extent that you're maybe like withholding certain types of AI resources from the public, or we're attempting to maintain a monopoly over legal knowledge. Like, again, to the extent that we just continue to privilege ourselves in that practice, that can't. Yeah, I mean, like that can't survive. But I would also say, I would offer that what I've seen in the advent of the era of generative AI, we're recognizing more and more that the value that the lawyer brings to, or the legal professional brings to the client relationship isn't as much knowledge as judgment. Mm-hmm. And so I think that there's something to be said for that, and whether AI will be able to, like, I don't know, agenically develop that judgment. I have my doubts, but I think that's something that we would think about as well.
Yeah, that strikes me as that is where things are going up, and I do think that positions professional identity even more recognized than was the role of the lawyer.
Yeah, I would say the same thing. I mean, my initial thought was similar to Janice's. I am a fan if we can get the right sort of, parameters and guidelines around it of making legal information more accessible to non-lawyers. I think we are where we are because we have sort of sat on this information for a long time, and it is uncomfortable to think about, parts of the things that have given us value now being released to the non-lawyers. But if we are truly committed to access to justice, we are truly committed to making the system better, and our sort of responsibilities that are outlined in the preamble and other places, then we have to get comfortable with that. And we have to, with the right guardrails in place, and it then calls into question for the lawyer, well, what is my value? And it calls into question for the law schools, I think, what is the lawyer's value? And what should we be doing differently to communicate to new lawyers what their value is, to restructure our curriculum around knowledge of the law, which is not unimportant, but may become more easily accessible by non-lawyers. I think relative to licensure, the bar exam in its current state, and there's, the next gen bar exam, I didn't spend a lot of time talking about it, but there are advancements that are, coming with the next gen bar exam that are a good thing. But it is still an exam that is timed and it is based on memorization and is not truly going to tell us how will an attorney operate, what will their judgment be in practice when they have these tools, AI and others, accessible to them. And so for that reason, I think the alternative pathways, will give us a better opportunity to evaluate these things. And there's lots of stuff to be figured out there. Alternative pathways are very resource intensive from an evaluation standpoint for lawyers. So that's something we have to think about, but I think it does a better job of telling us, does a lawyer understand how to properly engage with the technical?
Yeah.
I was trying to remember this part of the preamble that was escaping me, but here I have it. But paragraph 12, this is what I was thinking about. The legal profession's relative autonomy carries with it special responsibilities of self-government. The profession has a responsibility to ensure that its regulations are conceived in the public interest and not in furtherance of parochial or self-interest concerns of the bar. There's no carve out there for except for AI.
Yeah.
Right. Yeah. But I think we need to take that seriously.
Yeah, totally. And I mean, as someone who's worked in the access to justice space, that it was a stark splash in the face that most state bars, bar organizations are trade associations first. Yeah. And the public interest isn't the touchstone as it should be. But yeah, I mean, I think the next generation bar exam is still going to be heavily used in college testing. Yeah. Which is funny because it took them 10 years to get here, and they're in trouble.
Follow up to that question. So I see an analogy here to the shift from doctors being the only people who can prescribe medicine to a nurse practitioner being able to do so. But I still can't go on WebMD and prescribe myself things. So how do you see that mapping? And do you see something similar happening within the legal sphere? How do you see that differing?
Yeah, I can only speak to what's happening in Minnesota. It's, I think, the space that I'm most knowledgeable about. We are in Minnesota, we're exploring through the Bar Association building sort of altering, we'll say that, kind of altering or making adjustments to our sort of unauthorized practice of law rules. And it's still very much in the development stage, but to your point, there's a difference between getting information by myself as a non-lawyer and then doing something with it. Just like there's a difference between getting information about what, I'm self-diagnosing on WebMD, but then can I do something with it to make myself feel better? And as we're thinking about technology and AI, we're running into that same barrier. I can get information, but then can I do something with it as a non-lawyer? And it is going to force us to, as a profession, one, get comfortable with what we were talking about before, and sort of expand that. And then it's going to require, I think, specific rule changes because there are rules in place that would say that that's not possible right now. So.
Thank you again to our three panelists. I invite you to go across the hall, get some more snacks, use the bathroom. We're going to take a 15-minute break and reconvene at 2:15 for our final panel.
My name is Jerry Organ. I'm co-director of the Holloran Center. And I have the privilege of moderating this last panel, if you can call it moderating. I have with me two wonderful friends of Holloran. My immediate right, Leah Teague from Baylor, and seated next to her, Erica Punt from GW. Erica is known to some of her colleagues as someone who doesn't like rules. So I want to thank every other panelist for complying with the rules. And then I just want to note that this panel is going to be something a little bit different. And I'll let it stay there and I'll get them started. So
perfect. Thank you. Thank you so much. I cannot start anything in this building, in this space, without thanking, and I'm going to get Terry here. Thank you for allowing me to understand that if you get teary, it's because you've spoken truth within a space in which you are comfortable and feel trust. Isn't that beautiful? Learn that today. Okay. To Neil, to Jerry, to David, to Lou, to Barbara, to Kendall, and all of those who so greatly influenced me, thank you so much. And I've heard this before, and I feel it again. I'm going to be mentally exhausted by the time I am finished with this day, yet completely supported and loved. That is the experience that is a Holloran Center workshop. And so we thought it was very fitting that in this last hour, when we've been here all day and we are mentally exhausted, that we do change it up a little bit, and there will be a little bit of workshopping true to the Holloran Center. So that's where we begin. When Dean Kelly started and then Neil, and I love that UV is at the center of recognition of exactly what we're going to say. With AI, all that the Holloran Center stands for is doing is even more important than ever before. So if that's the takeaway that you get from us, then we've done our job, and you heard it first and you heard it throughout. A couple of other things I want to note because it flows so nicely into what we're doing. Daisy, thank you for saying we got to name it. The whole leadership development effort was started because we're doing it. We are developing law students who will become lawyers, who will be in positions of importance, influence, impact, and yet we're not intentional. And the same thing with all that we're doing. So this is about the naming it, and so now we're going to add in the AI and understand that. Ben, the moral drift, the meaning and purpose is the anchor that spoke to me because for me, leadership development is about helping our students have success, understand their obligation to serve, and through that, there is significance in meaning and purpose for them personally. So all of this just so resonates. And then for Neil to bring it back to the human-centeredness. That is at the foundation of what we are going to talk about, practical judgment and relationships. That is where we are with generative AI. So with that, we are going to start. Now, I will have to say thank you to my assistant. ChatGPT has become my assistant. That's how I teach my students. It is your assistant. And just as you are responsible for whatever your assistant produces, you're responsible for the work product that your choice of generative AI tools will give you. And so I very much appreciate, I'm not a graphic designer, I could never come up with these beautiful slides. And yet ChatGPT couldn't do it a year ago. Now has produced these beautiful slides for me. So acknowledgement to my assistant. All right, we are going to start with a demonstration. Yes. Credit to Joshua Weaver, who is in Texas, works for the State Bar. His title is something about innovation and emergent technologies. When I called him and asked him to help me, he said, "Oh, Minnesota. I know those people. I love those people. I speak in Minnesota often." So the State Bar, Minnesota CLE programs, he's apparently part of that. So we asked him to help us with building a demonstration. Oh, that didn't work. Okay, so where do I think I'd go, Quinn?
Oh yeah, sure. Just come out.
Do I need to click on that? Yeah. Props. Oh,
yes.
Okay. So this is our AI assistant.
The wise owl study buddy, the US law. Go ahead. Ask me anything. I'm listening.
Yes, what we were hoping for, I know, which the research shows, right? What we were hoping for, we know the technology is available, that instead of a cute little owl is an avatar. And so I asked Joshua, do you let me use your avatar? And I don't really remember now why, but instead he gave us the cute little owl. But we know the technology is available for this to be very lifelike. So which question do we want to ask?
2.
3. Okay, we're on 3. We're on 3. I'm going to click on 3.
IRAP becomes your scaffolding. Lead with a one-sentence issue statement that names the legal question crisply. Rule, state the black letter rule, plus any sub-rules or exceptions you'll actually use. Don't dump every page. Application is where the points are. Walk the facts into each element of the rule, even the obvious ones, because you're graded on reasoning, not conclusions. Conclusion, one sentence. If you're pressed, skip polish, but never skip application. A messy answer that applies law to facts beats a beautifully written summary of doctrine every time.
What do we think? Okay, now, lest you think we have pre-programmed this, we did with 3 questions. But this has the ability for us to ask whatever question you want. So give us another question that you want us to ask. And we need it strong enough. My voice, when we were trying this out, didn't. So we need a question. Yes. Okay, I'm going to start it.
Why is professional identity formation important in law?
Okay, I'm going to click on ask. You're going to ask. Perry's going to answer.
Okay. Why is professional identity formation important in law schools?
Identity formation helps students figure out who they are as lawyers, not just what lawyers do. The ABA now requires it under Standard 303 because technical skills alone don't make great attorneys. Think of it this way. Knowing contract law is the toolkit, but understanding your values, ethics, and sense of purpose is what guides how you use those tools. Students who develop strong professional identities tend to navigate ethical dilemmas better and find more meaning in their careers long term.
What do we think?
That wasn't too bad.
That's pretty good. I think you didn't need to invite any speakers.
We're having Harry for our symposium.
Yes, I'm so sorry. I clicked out. Okay, so questions are raised. Why are we needed as law professors? Those of us, right? We are still needed. But what we have to recognize is this tool is available. And that's how we have to embrace that. It is the new tool. How many in the room remember when Lexis and Westlaw were first a thing? Yes, it was scary and it was different. Did it take away from who we are as lawyers? It absolutely did not. It was a tool, it was a help for us without a doubt. So the question that we are here to address is, as AI reshapes legal work, can students sustain a professional identity worthy of public trust? That's what's important to us. So appreciate very much this morning, Tim, referencing the preamble. You have a handout. I think you all have a handout. This is a handout that I've used before, and I've adjusted it to incorporate the disruption that generative AI is the havoc that it's creating, right? So the question is, how do we help our students sit in that tension of recognizing that we have a professional obligation to, how are we supposed to represent our clients, advocate for our clients? What's the word? Zealous. We are zealously to represent and advocate for our clients. Yes? But if we look at, and that's why I've broken it down for you, in the preamble, as was mentioned this morning, we have an obligation, loyalty, zealous advocacy for our client, but the preamble identifies two more important roles, three roles that we have. The first one is to the clients, the other two are to the system, as officers of the legal system and to public citizens with a special responsibility for the quality of justice. And in bold is the new tension identified that AI has presented us with. But we have always had this tension of what do we do when the client's desired outcome stretches us, not in a good way, but beyond the ethical or factual boundaries. We've had that. That has been a tension. And so now we're going to talk about the additional stresses that are going to occur because of AI. So I'm going to skip that one. Our obligation to the court and the system of justice, when advocacy and negotiation risk misleading or undermining justice. And then the third category, when tactics behavior damage public confidence in us as the guardians of the rule of law. So in all that we are doing, it's to try to help the students see themselves in those very important roles, and then to help form them in a way that they are prepared for the tension, for the stresses when they face them in practice. Okay, so what we're saying now is AI just creates a new layer of tension, which not only supports the work that the Holloran Center and all of us are doing, but has been said from the very beginning, it increases the need for not just the skills training that we have been doing a better job of in legal education, but professional identity formation, character development. And I want to shout out where is Kenneth? Oh, there's Kenneth and Ben from Wake Forest. They're the ones in the last few years have named it. We were doing it intentionally and unintentionally, but they've named it. It's important that we do character development with our students in the law schools. And then the leadership development, because we know that they will all be in important positions of influence and impact, and that's leadership. So even if they don't hold a title, hold a position of leadership, they're doing it in everything that they do in their lawyering task. So that's where we're at. AI is not going away. It is the new tool on the block. And so the question becomes, how do we prepare our students to deal with these tensions? So first, I think it's important that we understand, why will our students be tempted to rely on AI? You've heard this from the very beginning. It was just this week, right? Sullivan and Cromwell got hit again. I don't know about again. I don't know if they have in the past, but we had another major report about a law firm, very prestigious, very capable, good law firm, And yet there was a hallucination in a document that was filed. Do you know what the response was? There was, I wrote it down to make sure I didn't. There were internal safeguards bypassed. It's not that they hadn't thought about this as a possibility, right? Not that they didn't try to do something, but there was an internal failure. So it just makes the point, it's even more important than ever before that we have each and every one of our students leaving law school understanding who they are. What are their values? What are the values that they hold personally but professionally? What are those lines that we cannot cross? Right? Okay, so you help me. What are some of the reasons that students are going to be tempted to rely on AI, even if it ends up to their detriment? So let's think about this. Why do people do things? Either because it's convenient, it's really easy, doesn't take much effort, or there are incentives, there's rewards. What are those? What?
Fear. They're avoiding fear.
Fear. What else?
It's built to sound authoritative. It's built to engender our trust.
Yes.
We're humans.
Yes. What else?
Time.
Yes. Anything else?
Okay.
One. So speed and efficiency. Self-doubt. Now, I didn't initially attach imposter syndrome to this, but let's think about it. What is imposter syndrome? Not good enough. Okay? So we all suffer from some sense of lack of confidence in new tasks, in new areas. And we got this thing, the internet, that has all knowledge, no knowledge available to it, right? Why wouldn't we think that my answer is not good enough, but what this program generated, it can be trusted. It's better than I am. We're human, after all. Dehumanization. People are messy. We've heard the term relationship. As a young workhorse, I did not understand how important relationships were. Give me a task, give me a job, I'll get it done. It wasn't until later that I understood, no. Life is about people and relationships. That's messy, that's difficult. And relying on AI doesn't require that. Okay. Scalable and amplification. We can do more. Access to justice. There are some problems that we have, and this could be the answer. So there are all sorts of incentives, reasons why we need to embrace generative AI. We all have colleagues that aren't there yet, right? So for some, it's just a matter of helping them get to it's not going away. It isn't the end of our profession. We're going, as long as we do it well, right? Okay. Don't need to come back over. So what I've done is just to think about this and to name some of the concerns, stress points to our professional identity formation work. Ownership drift. The tool did it. So human agency dissolves into process. We're just going to mindlessly trust the thing. Epistemic overconfidence. It sounds really good. I couldn't have come up with that language. It sounds better than me, therefore I'm going to 100% trust its judgment, regardless of how shallow it might ultimately be, or the lack of the wisdom. And we have to recognize for our students, they don't have experience. And so much of wisdom, judgment, comes from knowledge, skills, and experience. And so no wonder they tend to rely. We all do that, right? In an area where we're not comfortable. Confidentiality erosion. This is a big concern, where client data is treated as a mere input rather than seeing the person and wanting to protect that person, that fiduciary obligation that we have to our clients. And then we know, we've heard, justice blindness. So because it's based upon the input, if the input has a bias built into it, the output is going to be biased, right? You've all heard that. You've all heard that. So how do we fight against that? We have to recognize it, we have to name it, and then we have to fight against it. And then because of that, we end up with decisions, outputs that we don't like, and harm that will go unseen without some intentionality. So here's what we end up. The dangers as I see them. Convenience displaces accountability. Efficiency bypasses integrity. And scale forgets to be human. So in the second handout that I have, it's another, handout checklist, which is intended, and this is my first shot at this. So I am very open to suggestions. And I started with 4, and then I ended up with 5. So I'm going to run through these very quickly about what, in my mind, this looks like. So this is about how do we as individuals, how do we as professors get our students to be intentional to understand the dangers of relying too heavily on generative AI. Start with, got to own the work. Have to own the work. And that's why I think if we can help them see AI as an assistant, and you're responsible for all your assistant's work, then we're going to allow AI to do its thing, help us, but we still own the product. So judgment and consequences have to remain ours. Earn trust verification. There's absolutely no reason to skip that. Bypass internal safeguards. We have to verify. We absolutely have to verify. Short client confidences. If our clients can't trust us, we have lost as a profession. We have lost as a profession. And if we get lost as a profession, so does our rule of law, so does our system of democracy, because we are the safeguards for all of that. So very important that trust is something that we treasure and that we work really hard to gain those trusts and keep it. Serve the system. It goes back to we are not just zealous advocates for our clients. Our role is much broader. And we have an obligation to the system. We cannot forget about that we owe a duty of justice and to protect the rule of law. And then last, this is the one that I added, because you can argue 5 and 1 are really 2 parts of the same coin. If we're going to exercise our legal judgment, that means we are owning the work. But as a checklist, I've added it as a separate one, really as a final check. When we're done, let's make sure that we are really owning the work product that our very capable assistant, but not perfect, and doesn't know the client the way I know, doesn't know the factual situation, isn't thinking about the moral consequences of some of this and the bigger implications. That's my job. That's my job as a lawyer. So I'll leave you with, great lawyers are skilled advocates, trusted professionals, ethical, should be leaders, not leadership, responsible public citizens, steadfast guardians of the rule of law. That's who we're supposed to be. So if we can help our students see themselves as this, then hopefully we've laid a foundation that will help them get through the pressures that we know are going to hit them. So in an AI-shaped profession, these qualities, these competencies, these descriptors are even more important, not less. So I don't see professional identity formation being threatened by AI. I see it as an opportunity for us to be the ones to reshape legal education, therefore help form a better legal profession in the future. And with that, we need to switch, turn it over to Erica, and then we'll do our thing together. Thank you.
While Quinn is setting up my presentation, I would like to just offer a totally non-defensive context for the rule-breaking aspect of this presentation. Just to share with you, Leah and I actually submitted 2 separate proposals to speak, and both of us offered frameworks for thinking about professional identity in an AI-saturated world. In a typical Holloran Center form, once we figured out that we had these two presentations that were very much in conversation with each other, we were eager to collaborate across the two presentations and pull them out, really because there's so many synchronicities between what I was working on and what Leah was working on, and we just had no idea. So I'm grateful for her collaboration. So the collaboration was one piece, and the other piece of this was we were very alert to the fact that we were presenting later in the day. So we were eager to mix things up for you. So I'm going to talk to you for 15 minutes max about just some things I've been thinking about around this issue. And then we have a Jerry Oregon-inspired workshop aspect to the programming where we're eager to get you talking about some of the challenges and opportunities that you see. So let me take a look. Oh, I think I need to be in present mode. All right. A few very brief opening remarks of gratitude and optimism. I'm so grateful to be in this room, and I'm so grateful to have been trained by the Holloran Center, and that we're all thinking about these issues way ahead of the game, and also coming from a place of great optimism most of the time. And when I say optimism, I'm excited about the theme that's come up throughout the day, that it allows us a chance to really center the more human aspects of lawyering that, frankly, I'm much more excited to teach. I don't want to speak, I see my colleague Katya nodding. That's what lights me up at the end of the day. But because I contain multitudes, I don't always feel that way, especially when my slides are like this. Often I feel a little bit more like this, completely overwhelmed. Overwhelmed about what our future holds, overwhelmed what our role is in this process to shepherd students into an AI-saturated world. And I've been thinking a lot, really sitting with my feelings about why do I feel so overwhelmed by this particular topic? And I've come around to two, I think, buckets of ideas that I want to share with you because I think they contextualize why this is a formation issue at all. The first is that this is the first development. It's unlike Westlaw in this case. The first technological or other development that is impacting us beyond the legal services field, beyond legal education. It is everywhere. And even when I want to take a break from all of the thinking I'm doing, I'm confronted at every turn with, I'll give you 3 examples in real time. I wanted to catch up with a little reading on the plane. So I packed up some old magazines, and the first one I pulled out, I don't know what's the back, you can see this, but it's this graphic, this kind of 1950s style comic graphic where it's an AI kind of robot with lasers wreaking havoc at the bottom, and there's a human with a thought bubble that says, on the other hand, I've never been more productive. So I'm like, there goes my leisure time. Thank you, Leah. And then again this morning in the hotel room, I'm talking to my non-existent Alexa, asking, what's the weather outside today, Alexa? Doesn't know, she's not there. And then the third real-time example was when I tried to correct the spelling mistakes in this AI-generated slide. Maybe this is a testament to my own lack of resilience, but ultimately I gave up and decided it was going to be part of it. It's problem 1, or the overwhelmed category 1. Overwhelmed in category 2, and we touched on this throughout the day too, is this is touching something that is very central to our identity. It's really triggering, at least for me, lots of questions about what are we even doing? What does it mean to practice law? We talk about retaining professional judgment in an AI era. What is that? Have we even really defined it in a way that we're comfortable? And then maybe most existentially, what does it even mean to be human? What can computers do that we can't? So it's sort of all encompassing in a way that becomes really hard to advance the ball. I've been thinking a lot. My dad's high school yearbook quote was, it takes all of the running you can do to stay in the same place. And I feel very much like that with AI development. And I share that with you not so I can monopolize my podium time to tell you about my feelings, but I think because it's relevant to the formation question. We know, like our gut tells us, this must affect professional identity formation. And it must do so in a really profound and multifaceted way that I think at least I'm having a really hard time getting my mind around. And I feel significant or sufficient overwhelm that I sometimes feel like I can't make a contribution in this space, that I don't know enough, that things aren't static enough. So I feel some degree of inertia, maybe driven by imposter syndrome, about what I even have to say. And I wonder if others in the room feel that. So it's been useful to me to center. We know intuitively that there's a potential disruption to professional identity from AI. And I choose the word disruption really intentionally because it could be a positive disruption. It could be an accelerator in some respects. It could be neutral, or it could have negative ramifications, some of which we can anticipate, some of which we cannot. And I found it really useful. I tell my students when they're overwhelmed, go back to the basics and go back to what you know. So I really ground myself in the Holloran Center training and what it is I know about, or I think I know about professional formation. I know that we make certain assumptions that identity develops through stages, not all at once, and that students enter at an early stage of self-directedness. I know growth requires goal-setting, feedback, reflection, and ownership, which is one of Leah's concepts. And that development ultimately moves forward to an internalization of our obligation to clients in the system. Where I start to think we might see disruption is AI, and we've heard about this a little bit, that it can present like really fluid outputs all at once. So I worry, or I worry with a small w, as I say to my students, that AI might let students play advanced reasoning before they develop the professional habits behind it. That's something I think we might all be thinking about. And I ask myself, if students can stimulate later stage performance, do they progress through the other stages? And I worry that formation may depend on conditions that AI is going to alter or eliminate. And I'll talk more about that in a second. So ultimately, I land on my modest sort of proffer for you. I'd like to talk with my remaining time about how AI might change the developmental path, how to preserve judgment in a world where it has to be outsourced to AI, how to design for productive struggle in AI-saturated environments. And then I have a really modest framework that's really in conversation with Leah's framework called Interrogate, Humanize, Translate. If you have a sexier acronym you think I can incorporate, I am all ears. Okay, so speaking of going back to my Holloran Center training, I've really had in the back of my mind the competency alignment model. So this idea that we eventually move from novice learner, and here's where most of our law school students are entering, ultimately something that looks more like mastery through practicing lawyer. And I've gone deeper than I had in the past because I sort of have just accepted, and I continue to accept, that this is the development structure. And I've gone a little deeper into Dreyfus. Dreyfus underlies the competency model that the Holloran Center has presented to us. And it's this same sort of idea that you, through stage development, proceed from novice, someone who really relies on rules. They wouldn't be a rule breaker, so I'm not a novice in this case. And ultimately move their way towards expertise. Where I think this gets interesting and where I've learned a lot is I was not familiar, and many people in the room probably are, about the origins of this skills development model, that the Dreyfus brothers were really talking about AI versus human reasoning when they established the competency model I just described in or around 1986. They were in conversation with what was happening in rules-based AI, and the idea was AI can really never be anything other than a novice. It's only a rule-following kind of logic-based system. It can never achieve the level of intuition that is required to master a skill or a concept. Something else I found that was interesting that I did not know, some of you might, is that this original study was commissioned by the US Air Force. So it had to do with how to fly planes. And I think to myself, of all of the things where I know there's technology behind it, I know a computer is probably flying my plane, and I hope that the right data is being input by the human, one. And two, that if something goes wrong, some human knows how to fly that plane, right? So I found that just a really interesting, because I was thinking to myself, is there a there? Has there been disruption to this competency development model that is produced by the AI disruption that we're thinking about? And I think the answer is probably yes. And I'm trying to dig a little bit deeper, and I welcome your thoughts on that. So I have two specific concerns that I've alluded to and that my framework is really trying to attack. Because as I mentioned to you, I can't do it all, and I'm sort of at peace with the fact that I can make only an incremental contribution. I'm particularly concerned, particularly with my first years. It's important to know I teach first year lawyering skills, what we call fundamentals of lawyering. And I'm worried about the fact that AI can generate a pretty polished work product without necessarily developing the internal understanding, judgment, accountability, or client-centeredness that's emphasized. Now you'll probably start to see hints of Leah's framework here. I'm flirting with this vernacular of the synthetic cognition, which is used in the literature to mean multiple things. And I kind of adopted it to mean polished performance without equivalent formation. That's what I mean by synthetic cognition. So it displays synthetic cognition without really exercising judgment the way a human would. The other thing that I'm concerned about is that AI removes friction. Leah was asking you a moment ago, why might a student use AI, or why might a practicing lawyer use AI? Because it's easier. And in some ways, in efficiency, that's fabulous, and it might be very well suited for certain tasks. But I think most of us would agree that productive struggle is required for learning. So I worry if we have too much frictionless learning or too much of an expectation coming into law school that it's going to be easy, we're losing a big part of the learning that we're trying to achieve, because learning does come from these things I got up on the slide, through uncertainty, through revision and critique, imperfect first attempts. Raise your hand if you haven't learned from making a mistake. And then ownership, real accountability, that you understand every bit of that output, that you can take responsibility and accountability for everything that output shows. So with those sort of really more granular concerns in mind, I developed a very, very modest, and I have a handout that's going to do a lot of the work here so people can stop talking at you and you can talk to each other. But I've developed a classroom framework for AI-enabled formation, and I'm going to give you the handout at the end of the session so you have a chance to kind of work with it and figure it out. But the ultimate goal of the handout is to do a couple of things. It's to demystify the technology itself. It's to really encourage students to work with the tools, but to work with them in a supported way. And the interrogate portion of interrogate, humanize, translate is to do what you might think interrogating. Is this the right tool for this task? How does the tool work? And a relatively rich understanding of how the tool works will really help the student understand its shortcomings and benefits. And after you've interrogated whether it's the right tool and you're using the tool, interrogate the output itself. And then humanize is to restore clients and your own judgment, kind of your context-specific knowledge into the question. So you've got your output, and then you're asking yourself, is there anything that's relevant to my client that's not taken into account by this output? Does this output actually serve my client? And then ultimately translating that output into advice, strategy, or usable legal advice. I see Jerry with the card, and I will follow your rule. But ultimately, the goal of the framework is to do what I said, which is demystify the technology, get the students working with it, but also to really bring front and center to allow students to identify and also reflect on these human-facing, client-centered skills that we're trying to develop. So, if interrogate asks you to not mistake output for understanding, we're trying to build discernment, judgment, confidence. We're trying to bring judgment front and center in a very visible way. Humanize asks you to focus on client-centered reasoning, ethical sensitivities, contextual judgment, professional instincts, all of these things that ultimately lead you from novice to expert on the development rubrics. Translate, again, legal judgment, strategic reasoning, audience-aware communication, and ownership. So all of these things that we're really trying to cultivate as a professional identity matter. Synergies between frameworks. I think Leah has highlighted the importance of responsibility, stewardship, and judgment. I see our frameworks in conversation, and very much so. Responsibility, I think, is built through interrogation. Stewardship requires humanization, and judgment becomes more visible through all of the steps, particularly translation. I'll leave you with this thought. I think that there's the rubric also, or I'm sorry, the framework, I think it tackles two challenges that we face at the moment. I'm finding my own students in the 1L year, it's really hard for them to trust AI tools. I don't know if the students in the room feel this way, but many of my students, I think, came up in an environment where the tools were prohibited, was a violation of academic integrity. So getting them to use them at all has been a struggle. So I think the demystification process this framework gives you is going to help those students. I fear a little bit that students coming up will need a little bit more emphasis on the portion of the programming. I think there's jury's still out, I think, about what impact growing up in an AI-saturated environment has on our cognitive growth, our ability to, I see lots of nodding in the back, that makes me feel like I'm onto something here, which is great. So I think there's reason for optimism, but also reason for measured introductions to AI. I have more slides, but I'm watching my time and I have promised that we leave adequate time for the discussion questions. So with your indulgence, I'm going to skip ahead. Oh, I welcome your feedback. I'm going to turn out, in the interest of continued growth, I'm very curious to know, after I pass out the handout, does it work for you? Do you see room for improvement? Did you use it in a specific context that you found really helpful? Okay, to review our questions? Yes. Okay, amazing. So we're going to ask you to form a small group of no more than 3 with the folks around you. Does everyone have my required to turn around?
Sure. Yeah, we should roll.
Yes. Okay, are we ready for the questions? All right.
We're going to go ahead and keep time, and we invite you for the next 10 minutes to talk to your groups about the following 2 related questions.
In this order.
Yes. The first is AI's impact on professional identity formation. So we're curious to know, based on what you heard today or what you're bringing into the room, how does AI threaten or enhance judgment, client trust, or otherwise threaten or enhance professional identity formation? That's question 1. Question 2 is, what should law schools change immediately? And then what should law schools change in the next 3 to 5 years to address the effects on professional identity development that you have identified? We'll give you 10 minutes to chat about it, call you back together, take volunteers to report out. Off you go. This is a test of how good is my theater voice after 20 years of being out of the theater. Can you guys hear me? Okay, I'm going to call us back together just to make sure that we have adequate time to report out. So we're curious to know, let's start with question 1, AI's impact on professional identity formation. Would anyone like to speak on behalf of their group about what sort of ideas they germinated in this space?
And we're expecting common themes to bubble up pretty quickly.
Yeah, we're also not afraid to call on people. Yes, please.
Yes. We're a group of students, so limited experience with clients. But one thing we talked about is, since clients are coming to lawyers sometimes with their own background research aided by AI, if we as lawyers can't add value on top of that, we're going to erode their trust in like us and the profession as being useful and helpful at all.
I think that's such an interesting point. Yeah, there's availability of information leading to potentially more informed clients, the value proposition. This goes to the existential question about what am I bringing to them? Yeah. Yes, please.
Yeah, so the perfect lead in for what we discussed. What is the value proposition? What is the value of what we started after that premise of it? The knowledge is free for everyone. It's that next step piece. So that's where the value is going to be. It isn't. You can have clients come to you and now understand that they may have an array of legal options, or they may know the nature of their legal rights. But where you bring the value, okay, what do we do with that? How do you exercise judgment or understand your client in the context of their situation with empathy to then help them choose the right path and then walk with them on that path? And what that's going to require is trust, a trusted advisor role, trust, empathy, judgment, all of the things that are less likely for the machine to replicate. And I think that's absolutely aligned with everything that we presented. And that, I think, elevates professional internet.
Is that awesome? Both of you. Yes. Please.
I'm not speaking for our group, but just to not agree with what he said. I agree with what he said, but see the thread is that the example of the assistant, just a great example. Normally, when we think about an assistant, someone who's more seasoned that is asking the assistant to help. That's not what's happening with Law, for example. The big thing about a new law student. A new law student is asking Claude to help with something. Claude knows a lot more in terms of accessibility to the algorithm for the student. So that creates kind of a work dynamic in that respect. And I think the way these tools are so much better at producing decent, not perfect. There are hallucinations like that, but they're getting a lot better. And so I think I see the threat, not to be a Debbie Downer, because it's so deceptive, particularly if you're trying to learn, move from modest to intermediate, you feed these tools, they give you back decent responses. And they also can serve as a proxy for judgment. So I completely agree with that. Yes, judgment, empathy, decision making, moral development, that's critical. That's the value that we add. But the tools are even very deceptive in approximating those.
And I'll just say I agree.
And the point on the assistant, in practice, I learned early on so much from my very seasoned assistant. But there was a point at which, and so that's for us the task. How do we get our law students to understand from the ownership piece? The ownership piece. I can't trust it completely. I can't use it without me thinking about it, without me using other tools, other approaches to make sure that I'm adding the value that I need to add.
And I worry, all of us have been raised in a somewhat, we have developed, everyone in this room has developed judgment in a somewhat analog environment.
Yes.
I have serious concerns for how your ability to distinguish something that's valuable and exercise your own professional judgment in a completely animated generation, that actually keeps me up at night.
Bill, can you read that quote again? Because I can't remember.
Well, I'm quoting something this being here. Productive struggle is required to learn.
Right. And so he shared that, and as you were talking, I was thinking about Susan's graph, right? Or her picture. Doesn't AI allow us to stay in our comfort zone?
Yeah.
Mm-hmm.
Right. And if we never step into the struggle zone, are we in a position to have the experience we need to develop wisdom, judgment, etc.?
Agree.
Right. So I think that's the challenge for us as educators.
Yep.
Is figuring out how to make sure, not that they don't use it, but then that it's used in a context that still requires them to struggle, so that learning is taking place.
That's on us. That is on us.
I'm glad it's on you.
I'll take one. I see two more hands on this point, and then we'll move on to the next question.
Oh, I just wanted to just add an and to Jerry's statement, and I think that it also applies to writing. Because for me, writing is often really a painful process. And the process of writing, often in that process, I learn new things. Things come together in my brain that actually then inform, what I ultimately say. And so to bypass all that and just have somebody else be doing the synthesizing or the whatever it is, I think there's something that's getting lost there or potentially getting lost.
The foundation of law school is critical thinking. It just has to continue to be critical thinking. So even as we're using this new tool, we are critically thinking about what it is teaching me and how I'm going to use it so that we don't delegate all of the judgment to this thing, to this tool. It's the way I begin to think about it.
And I'm with you as a writing instructor on the struggle of the blank page will remain in my syllabus until someone pries it out of my brain. Speaking of which, law school adoptions. What should we be doing in the near term, either immediately or in the next 3 to 5, to address some of the challenges and benefits? Yes, please.
I think, and so I'm in the Catholic Studies program and a dual degree program here as well, and we do some oral examinations, which I recognize is a huge burden, but we already have some of that in oral argument. And we briefly, as a group, talked about client interviewing. The tool is amazing. You can make it do all sorts of things, and as you become more adept with it, you don't even have to know the material to see where it's hallucinating. You can just, you see the patterns that it hits up, and you can just follow it. And I think I have classmates that can attest to that. But if you give a bad interview of your client, you can only give it bad information. And so you can't get a good result no matter how good the tool is, or it'll just make up facts, where you have to have some level of judgment to have a good interview. And then after you've maybe offloaded some of the granular reasoning and research, you can do, instead of ex ante, ex post learning to figure out some of that reasoning. And then you still have to be competent to present an oral argument. So I think as soon as you remove the computer and the writing from it, you can test knowledge very easily.
And I love what you said about the client interviewing oral piece, because I do think that client interviewing, client interaction, that's a place where it's really exciting to spotlight what's truly human skills. Client interviewing is more than just gathering information. It's reading the room, it's asking the right question, it's responding to interpersonal cues. I think when we have a little bit more opportunity, because we've offloaded teaching where the period goes or what a dangling modifier is, I actually have time, right, to spend time with my first years developing something. I appreciate that.
So one of the things I was talking with Jerry about was the extent to which everything people have been talking about today relates back to social psychology research in the positive psychology field. There's actually a lot of empirical support for what everybody's been talking about. And one of the principal theories that has been pretty well established is that the 3 things that are most critical to well-being, particularly in a context, professional context or student context, are relatedness to other people, a sense of competence, and a sense of autonomy. And Larry Krieger's done a good job of bringing that to the forefront in the legal area, but there's just a ton of social psychology research that establishes that. And what I worry about AI, and what I think our students have to we have to discuss with our students, is that AI gives you fake relatedness, like it's a relationship with somebody, but it's not really a relationship. But it may make you feel like you have a relationship. So that you're going to want that because it's really hard. It gives you a fake sense of competence because you're not really competent, but it makes you feel competent. So it's really seductive. And it gives you a fake sense of autonomy because like, oh, I can control all this stuff through AI and it makes me feel like I'm more in control, but you're not really. So the seductiveness of AI, it's particularly for law students in their first year, is something that they're not going to understand well unless we talk to them about it.
Do we have time to take one more question, Jerry?
You do, and I hope it's more uplifting than Todd's observation.
Okay, pressure's on. We need an uplifting question.
Katya kept her hand up even when called upon to say something uplifting. Katya.
Yes, I was going to say ever the optimist, but in relation to what Jerry and Todd said, I wonder if there is also an opportunity here, though, to use the presence of AI to help us scaffold the professional identity formation of our students. Because as Ben said in his presentation, currently we are teaching all of these ethical conflicts and moral judgments and practical wisdom for the future in a very sterilized environment where our students are not really feeling any conflict. And of course, they can present as knowing all the answers because they're not out there. By bringing AI into the classroom and into the practice of law, all of a sudden they're actually living in that tension and conflict, needing to exercise their judgment today and their integrity today and all of that. And so I wonder if that allows us a much more active role to walk alongside them and scaffold their professional identity formation in a more real way rather than the perspective of life.
So on that point, thank you so much. I'm sure we'll keep
I need to say something else because that would have been a concluding remark, and it's concluding remarks, plural. So let me say thank you, and if we could all express our gratitude to our panelists today through a robust round of applause, that would be awesome. So to the students, right? I'm not sure. Well, I'd be curious if you're comfortable. I don't have an on-call list for today. But as Neil said, right, this is on your plate, right? More than it is on our plate. And so I'm curious about your takeaways. What's something you heard today that was meaningful to you or is something you really want to think about as you continue your legal education or transition into practice? So if a couple of you don't mind sharing a student perspective takeaway, that would be greatly appreciated. Thank you, Robert.
One thing that Professor Brooks, I think, said was the importance of what we're doing to our clients in the fact that we and the entire justice system are there being someone that is considering their problems seriously and answering their problems. Like this summer, I saw, it was just a settlement conference with an insurance company and someone whose son died. And it was the first time that she'd ever seen a judge. And it was like pretty low key, but you could tell how important it was to her that a judge and lawyers were taking the time to discuss her problems. And so, yeah, I think that just like keeping that in mind of how important that is a good takeaway for me.
Thank you, Robert. Rebecca?
Yeah, probably my biggest takeaway is like Professor Hamilton's response to my question during the first panel, and basically the takeaway I got from that was it's on us to kind of address these problems that are like the exact question I had. Like to some extent, we got to take it in our own hands and figure it out. And I found that inspiring.
David? Oh, wait, you're not a student. I'm sorry.
I'm a 27L.
Any other students? Grace?
I think, law school is very overwhelming in terms of taking in new information in many ways. So I've kind of put AI to the side in terms of, just not trying to figure out how to integrate it. So I will say that this has inspired me to work on that and try to be intentional about it, because I guess, it's not going anywhere. It doesn't sound like so.
I think that's a really good realization, right? I talked to one of our alums who graduated 2 years ago, May of 24. And he doesn't think about AI hardly at all. And he's doing great, but I'm thinking, I don't know that you're going to have the luxury of not thinking about AI much at all. Right? So I think he's just ahead of where you guys are. And so it wasn't part of the conversation really, but I think it's going to be intersecting with his practice soon. Right? So, Lily, was it?
Oh, yeah. I was just going to say a big takeaway I got was more of like with professional identity formation, the fact that being a lawyer is like our vocation and not just a career. And that's like big in forming your professional identity. And then also just for that first question up on the board, like AI doesn't like know about vocation, you know, it's just like the solid facts. And I feel like in my firm right now for criminal defense and the managing partner is big on like being the lawyer as healer. Like it's one of the healing professions and like looking at it that way. And it's like, if you give something to AI, it doesn't consider that when it's like giving you an answer. So it's like, you really have to keep that in mind when you're interacting with clients and other people. And
Anyone else? No, go ahead.
I very much appreciated Professor Kraft bringing LPE into the discussion of professional identity formation. I'm in their at-large student section, so I'm happy whenever we get a shout out. But I think that it's important to center this discussion not just on actually existing law students, but on those who are structurally excluded from the profession and think about how we could expand those walls.
Good. I'm hoping, I want you to all think about this concluding remarks session in the context of Janice Kraft's presentation, in the sense that she complied with the 20-minute requirement. But she had to have like 31 minutes of stuff there, maybe 33 minutes. I mean, it was just, wow, that's a lot.
Not demeaning.
Not demeaning. No, I'm affirming her because there was just so much. I didn't mean that. Okay, how about the non-JD students who are still lifelong learners? What takeaways might some of you have? Oh, come on, you're a robust crowd.
Yeah, in some ways I feel like I always feel at Holloran Center gatherings, right? I feel energized by people who are doing really good, important work. And I find myself thinking, how can we build upon this, right? How can we use this energy in productive ways, right? In service of our respective students, in service of legal education, in service of the legal profession. How can we make sure that we are not only continuing to build the depth of knowledge, right, in this professional identity formation space, but also connecting to all of the different communities that we're also a part of, so that this sort of diffuses outward. Because, going back to this question that we ended with, I do think that legal education is changing, or it's going to have to change. I think we're slow to change. But I think the next 3 to 5 years, and maybe a little bit after that, things are going to be shaken up pretty thoroughly, and we have to have some answers for what comes after. And I think many of us in this room are a little bit ahead of the curve based on some of the thought that we've given to this, and we can't keep our light under a bushel. We just need to get it out more and more.
God.
Well, I want to put a more positive spin on my last remark. Because honestly, listening to all of this has given me a renewed commitment to thinking about my students' well-being and taking care of their well-being and talking to them about their well-being and having a classroom that is designed to maintain and increase their well-being. I really do think that's going to be increasingly important. And I see that as a really positive thing that can improve the relationship between all of us and our students, because I think this is an opportunity to show them how much we are on their side and how much we see and understand the difficulties they have in law school.
We're going to be Neil Hamilton professors, everyone.
Should be so lucky.
So I want us to end on time. We have a couple of minutes left. That clock's actually a couple minutes fast.
When did you reset it?
We have, I was keeping time over here. We have the worst set of clocks. I think we're a great law school from an architectural standpoint generally, and infrastructure standpoint, but our clocks are not great. So I want to invite, right? So for those of you who've been at some of our workshops in the past, this concluding section would not be 15 minutes. It would be like 45 minutes. And part of it would be Neil and me, and once David got here, Neil and me and David asking for your counsel, frankly, about where we should be investing our energy and capacity in the near future. So I would just ask you, we're not going to have time to have that conversation right now. If you want to have that conversation over dinner at the awards dinner tonight, we can do that. But if you have ideas about what you think the Holloran Center could be doing, whether that's hosting, we are pretty good at convening things. So if there are things we could convene that would be beneficial, if there are things you'd like, a year, 14 months ago, we had a workshop, and the thing that came out of that workshop was Holloran has to do something about the rule of law. And so we formed a working group and we came up with some materials. We had a workshop in the fall on teaching the rule of law. The people from West here are going to be helping us disseminate those teaching materials in the coming months, assuming Kendall and I are able to get some editing done in the coming months. But so we've tried to be responsive. And so if you have ideas, please share them with us. And then we'll take that under consideration with our extended Holloran team to figure out where we go from here. One aspect of that, for those of you who we were able to celebrate today who are retired or retiring, I have to say that Neil and I have had this conversation. We see all of you as a great resource that we want to figure out a way to tap into. So I don't know what that looks like yet, but just expect a call. Neil, do you want to have the last word?
Hope everybody in the room feels how inspiring it is to be around other souls who are so committed to loving others, essentially. I'll just use love and service and care, right? I mean, we're trying to figure it out. You're watching the sausage getting made, actually. So you are watching the whole academy trying to figure out how do we help each other grow into later stages of care, service, love for our clients, for our team, for our employer, for our country, for our profession. It's very inspiring to me. Grateful.
And I realize it may have been exhausting to many of you, but I hope it's also inspiring. Eric Short can't be here, but he has captured my goal for all of the workshops and conferences we do. And that is, he describes it as exhausting but inspiring. And if I've hit that mark, I feel really good.
Hey, Jared,
thank you all.
David. 3 more groups here. First group we have to thank starts with Quinn and the entire University of St. Thomas Law Journal. And of course, we have to thank Felicia Bennett for making this happen. The best leader of any type of workshop retreat it has to be Jerry Organ. So thank you.